701.
Not before this bench, sir. You heard me.
Lord, apropos, Lord, yesterday, apropos, my Lord Justice Suryakant's query, Lord, I have about what amount was being paid from 1920 to 1950. 1950. But it emerges from the record, and I'll show that. But your lordships can take it from me. Both AMU and BHU were getting 1 lakh rupees each from the then Crown, British Crown, per year. That is, my Lord, emerging.
From, what is the dates from?
Lord, 1920
1940.
till the Constitution. So 1 lakh per year, both to BHU and AMU. Lord, sometimes at some point of time it was increased to 2 lakhs. And as on date, AMU gets 1,500 crores per year. And they also may have some self-generation of fees, etc., some 30-40 crores. Lord, I'll conclude my argument on the question of administration, for which I have compressed. I'm not going to read it, just for your ready reference. Lord, volume 2I, please see it. I'm not going to read it. I'll just show what it is. That as the Act stood in 1921,
That's good. That's nice. That becomes gold.
this is only reproduction of the sections. There's nothing more. Just for ready reference at one place, your lordships can get. But and I'll not read. I have read it yesterday.
Which page are you on?
2I.
How long is this note?
So 4 pages.
I read it now. It will be a good recap of your submissions.
Yes,
on this.
kindly, my lord, allow me, my lord. Lord, I have said that it was not established by the minority. Now I am on the question of administration, whether minority had any predominant role in the administration of the university as it stood in 1920, because that is the test your lordships would consider applying, not the test of today. Even today it's not, my lord, administration by predominant minority. But my lord, I am on right now on the Act of 2020. I'm sorry, 1920.
Yes.
A, as the Act stood in 1920, it was not administered by minority. Section 13 provides for Lord Rector. Your lordships have read, my lord. He had the supervening powers. Then 14, visiting board. My lord, your lordships have read it. I'll just read, my lord. No Muslim, my lord. The visiting board of the university, if and when the United Provinces of Agra and Oudh becomes a governor's province within the meaning of Government of India Act, shall consist of governor thereof, the members of the Executive Council, the ministers, 1 member nominated by the governor, and 1 member nominated by the minister in charge of education, provided that until a governor's province is so constituted, the lieutenant governor of the said provinces shall discharge and perform the duties of visiting board. The visiting board may, by order in writing, annul any proceedings not in conformity with the Act, statutes and ordinances, provided that before making any such order, the board shall call upon the university to show cause why such order should not be made. So university was subordinate and subservient to a body which was consisting of non-Muslims. Then your lordships may, my lord, see, officers of the university are provided under section 16, which also do not mandate to be belonging to Muslim religion. The chancellor, the vice chancellor, the pro-vice chancellor, your lordship would recall the court provision for court says that all members shall be Muslim. These people need not be Muslims. Then, my lord, there are three authorities. The court, executive council, and academic council. Though section 23(1) provides that no person other than a Muslim shall be a member thereof, the court was never conceived to be a body having power of administration, but was given only residuary power under section 23(2). My lord, the petitioners read first part saying that it would be the main body, without reading the second part, namely subsection 2. Provided that no person other than Muslim shall be a member thereof. 2. The court shall be the supreme governing body of the university and shall exercise all the powers of the university. They read up to this. Now, my lord, please read further. Not otherwise provided for by this act, the statutes, the ordinances, and the regulations. It shall have power to review the acts of the executive and the academic councils, save where such councils have acted in accordance with powers conferred on them under this act, the statutes, or the ordinances, and direct that necessary action may be taken by the executive or the academic council, as the case may be, on any recommendation of Lord Rector. Again, Lord Rector supremacy, my lord, is conceived. Then, my lord, 13, Lord Rector, the Governor General, my lord, now it is the Governor. Governor General shall be the Lord Rector of the university. The Lord Rector shall have the right to cause an inspection to be made by such person or persons as he may direct of the university, its buildings, laboratories and equipment, and of any institution maintained by the university, and also of the examinations, teaching, and other work conducted by or done by university, and to cause an inquiry to be made in like manner in respect of any matter connected with the university. The Lord Rector shall in every case give notice to the university of his intention to cause an inspection, so and so, so and so. Please see 5, subsection 5. Where the court does not, my lord, he has a power to direct the court that you do this. Where the court does not, within reasonable time, take action to the satisfaction of the Lord Rector, the Lord Rector may, after considering any explanation furnished or representation made by the court, issue such directions as he may think fit, and the court shall comply with such directions. My lord, the simile which was sought to be given, that your lordships are visitor to some university, Lord, is not a simile in the context, is not the correct simile in the context of the question your lordships are deciding. The question is, who is the ultimate decision-making authority in terms of administration?
There are two ways to look at administration.
My lords.
One is with whom the absolute or the final power is vested.
Correct, my lords.
The other is day-to-day administration, day-to-day running, functioning of the institution. The day-to-day functioning is done by the people who are at helm of affairs, who are hands-on. Lord Rector, being the direct Governor General or somebody, will be having numerous functions.
Correct, my lord. On site, who is, my lord, either of them, my lord, there is no dominant control.
So, as per your argument, it's going to be these, the ultimate authorities and not the ones who are, because this argument proceeds on the basis of the one who are actually running the day-to-day administration. Like in criminal law, the persons in charge of and responsible for administration are the ones who can be prosecuted. Day-to-day affairs of administration,
Right.
and not the one who's overall in charge, or not the one who's a symbolic in charge.
Yes. My lord, even day-to-day
Our argument, which is to be answered.
Please.
This has to.
No, break, Mr.
What?
Lord, my
I
decency
hope
be
we'll
not
get the
treated
time.
as my weakness.
Fine.
Mr.
He's not responding to our argument. I hope we'll get the time.
Dr. Lavan, we'll hear you and rejoin. There's no difficulty. We'll hear you. Yes.
Lord, here, even day-to-day administration is not in their hands. Lord, the court was consist of some 100 and some odd, my lord, people. Lord, they can't be running the
actually,
administration.
Mr. Solicitor, the argument which was made on the other side was this, that you have
you can establish institutions of your choice, and you have a constitutional discretion to administer it. But if you give that discretion, exercise that discretion by giving the administration to others who do not belong to a minority, that does not detract from your position under Article 30. For instance, in any educational institution, there will be non-minorities who will be an accountant, who will be performing other ancillary functions. That by itself may not be an indicator that you cease to be a minority.
Even that discretion is not there. That's what attempt, my lord.
Yeah, of course, you have said that, here the statute superimposes the Lord Rector. And
Yes,
we'll hear the other side.
I'm saying something else, my lord, something else as well. Even in terms of amending the statutes, they have no supremacy. They can amend the statute. It is always subject to the rector, the Governor General in Council, full right to set aside it, remit it back, or say that I don't accept it, reject it. So, meaning thereby they had a kind of advisory function. This is what we think the statute should be, and according to us, this is how the administration may run. For example, the statute concerns the administration. That also, my lord, the discretion also is not conferred. Please, my lord, see further.
Obviously, it was the policy of the British government to not make this an absolutely autonomous institute. They were retaining some element of control over the institute.
Substantial and predominant, that's my submission, control. And my lord, this statute be not examined, my lord, my respectful submission, in the context of or under Article 30. It was not there. If any parliament were to make this statute, possibly an argument, not possibly, argument can be made that this is violating of Article 30. But there is a history behind it, that we will have control and there would be no denominational character. Are you agreeable? They said, yes, we are agreeable.
Anyway, there is no challenge to the provisions of the Act.
There is none. Well, even the
Therefore, we proceed on the basis that the Act is valid.
amendment is not under challenge. Post-constitution amendment is not challenged under, my lord, except 81 amendment.
So we take the Act as it stands and see what is the impact on its minority status.
Yeah, kindly, my lord. Therefore, my lord, kindly see, my lord, para A. The power to establish and maintain colleges and schools was subject to...
If a similar provision were to be made today, would that detract from the minority status of the institution?
It may, my lord, it may. My lord, but the government may not, my lord, the present government under the constitution cannot compel them that either of these things to you agree, otherwise will not pass an act. I am not for a second saying that that's the prerogative. The legislature may in its wisdom say that we will accept this or we will not accept this, but subject to judicial review. But in 20, the Crown,
the true test would be this. Which of these provisions are relatable to the overall regulatory power of the state, which even Article 30 allows, and which of these provisions go beyond what is really a regulatory provision, which is agnostic to religion,
correct, my lords,
and then destroys the minority character.
Correct, my lords, but please, my lord, again, my lord, at the cost of repetition, please do not read 1920 Act in the context of Article 30. It is at a period of time in history where Article 30 was not there. Indian Constitution was not there. There was no concept of minority. There was no concept of fundamental rights. And the British government was in a position to put its terms. If you want this, have it. Otherwise, others did not agree. They started their own universities and started conferring degrees. Because till 56, it was not impermissible to have universities and degrees. This degree was needed by the Aligarh Muslim University.
Really speaking, what your contention boils down to is this, that this was not a denominational institution when the university is established in 1920. Therefore, the subsequent development, namely the adoption of the Constitution on 26th of January 1950, cannot confer upon it a denominational character for the reason that you had bartered, you had surrendered that denomination.
And that is the ratio in Basha.
That is your submission, which we got the point. We'll have to hear the rejoinder.
Lord, kindly, just quickly, my lord.
Yes.
Section 12.
See, let's see section 12.
Section 12, my lord. 3, my lord. The most important power for any university is to affiliate other colleges, etc., my lord. That's the most important administrative power. Please see. The university shall, subject to statutes, have power to establish and maintain intermediate colleges and schools within such limits in the Aligarh district as may be laid down in the ordinances for the purpose of preparing students for admission to the university and may provide for instruction in the Muslim religion and theology in any colleges and schools with the approval of the academic council and the sanction of Governor General in Council on the recommendation of the visiting board and subject to such conditions as may be prescribed by the statutes and ordinances, the university may admit. So, my lord, first supervening power of Governor General in Council, this is the major administrative act. Thereafter, the visiting board and subject to the statute, and your lordships would recall, the first statutes were framed by the imperial parliament itself, providing that you cannot amend that statute without my permission. Even the ordinances were framed by the Governor General in Council. So please come to page 4.
Didn't want to give a complete free hand, being, they realize the importance of education and the impact they'll have because
They wanted a degree, and for that degree had a price in those days, price not in terms of money, that you have to accept what
perhaps
government
more
says.
than that. It was perhaps more than that. They wanted to have control, overall supervisory control, so that they could intervene and interfere.
In the administration, there was no absolute discretionary administrative power conferred under 1920 Act. And the history, my lord, is the proof of that. That we will have two things, no denominational character, and we will have administrative control. And they were in a bargaining position. There was no constitution. Having a minority institution or having a university was never a fundamental right. And majority of them did not do it. They accepted, Manoj. And I wanted to cite, but I am not citing, Manoj. I request somebody else to cite. Manoj, one of the latest written by the then management to the governor, Manoj, is shocking. That we want that your British administration continues in this country forever. It's a boon for our nation, etc. But I don't want to digress from that. But my colleagues are citing it. Please come to page 4. So that was the mindset or the object which they are entitled to have. They were entitled to have. With which, they surrendered everything. And let check whether we discussed that.
basically this is a pre-constitution institution.
My lord.
We will have institutions which are claiming the right under Article 30. Any institution which fulfills the requirements of Article 30 is entitled to claim a right post-constitution, irrespective of whether it has been established prior to the constitution or after that. The law is not that you can claim the right under Article 30 only if you have been established after 1950. Now we are dealing here with a pre-constitution institution. Second, an institution which is governed by a statute.
Correct.
Now, there are certain, and we are looking at the antecedent facts prior to the onset of the Constitution, prior to the adoption of the Constitution. We have to also understand that that was a period when there was absolute control which vested in the imperial power, right? Now, to what extent was this absolute power, which was yielded by the then imperial government, so destructive of any claim in regard to minority status post-Constitution? So, contrary to what you are saying, we are not applying Article 50 to a situation pre-Constitution. To a certain extent, you have to do that exercise. Otherwise, we will be coming to the conclusion that no pre-Constitution institution can claim a constitutional right under Article 30. That's not the position. We can't say that a pre-Constitution institution is not entitled to claim the right under Article 30 of the Constitution. Obviously, they are. So long as they satisfy two yardsticks, namely of being established by a minority and two, being administered by a minority. And now here, there is an issue because you're placing in issue the fact that this was really an institution which is established by the statute, according to you. That's what the preamble
They had
said.
other options of establishment.
That they need not have gone the statutory way. According to you, they could have followed the Vishwa Bharati route. You could have,
Yes, yes.
or any other institution.
I'll not surrender my rights and
where
they
you
claim their
don't
right
seek,
after
you don't seek recognition of your degrees, in which case you could have just said, well, I'm going to be an institution which will be standing alone on my degrees, even if they are not recognized.
Stephen did it.
My students will not get government service, but so be it. Many other institutions did it. Stephens did it. Vishwa Bharati did it. That's one aspect of the matter. But does the fact that they really chose the statutory way, is that so destructive of their claim to minority status? Post-Constitution.
Your lordships, with a profound
In which case we will be saying that once you accept the fact that you will be governed by a regulatory statute for the purpose of the
It's not
conferment
a
of
regulatory
degrees.
statute.
It is a regulatory statute.
No, it's a substantive statute providing for substantive either power or lack of power.
But regulatory statutes are also substantive. They're not procedural.
There are three things, my lord, in this statute of 1920.
Does that completely destroy its claim of minority status?
Correct.
Or are these provisions which are designed to ensure the proper administration? Now, Governor General, let's take the case of the Governor General. You will find in a large number of institutions today, there is an approval required of a government officer, minister in charge of education. Are these really, in that sense, are they controlling influences?
Or
Are they in the manner of an overall supervising influence to ensure that nothing drastic is done? We must also understand that the British government they had sensitivities. They didn't want any one institution in India to become so powerful so as to affect the imperial dominion power.
No, they say otherwise.
They were not running these institutions.
I'll answer that.
This was all designed to ensure ultimately that no institution went out of the mainstream as they wanted it.
No, my lord, and some movements which were started doesn't spread across the nation. That was the reason, the movement of independence, and that was the reason why most of them said, no, we would prefer movement and not your.
Therefore, all the regulatory statutes were intended to provide one overarching objective, and that objective was nothing should be done to destroy the hegemony of the imperial government and the colonial power. Protect the colonial power.
No, maybe as a general
And
purpose.
education is a very important source of, it's a power, source of cultural power. And we have seen it pre-independence and we have seen it post-independence.
May I answer your lordship's question? Lord, first of all, the establishment is a fact which is pre-independence, which cannot be wished away even after the independence. How it was established? Number one. Number two, in my most respectful but very emphatic submission, These are not regulatory provisions. These are substantive provisions, either conferring powers or not conferring powers. Number three, when we talk of administration, Lord, we never talk of administration in air. Administration is always a layered exercise. For example, administration of a court, let's say for a particular high court, there would be 5 registrar generals, registrars having different powers. They would be administering, but according to what? According to something which is decided by some higher authority. That higher authority would not be doing on day-to-day basis the administration. Thereafter, the administration would percolate, but ultimately the controlling thing would be the statutes. Controlling thing would be, in case of a high court, the resolutions, the constitution, etc., passed by the competent authority who has the ultimate control. So, my lord, please, my lord, do not take these as mere regulatory provisions. These are substantive provisions. Either we confer these rights A, B, C, D. You are not supposed to do X, Y, Z. It's very clear. These are power conferring substantive provisions under the 1920 Act, not just regulating who will administer. They are not, my lord. Therefore, my lord, please see, my lord, page 4. Please see page 4, my lord. And establishment is a factum, whether I succeed or we succeed or other side succeeds. Establishment is a factum which has taken place in 1920. That cannot be wished away. What the British did may have been completely wrong, but it has happened, and majority of the institutions have chosen to ensure that that does not happen with them. They came after the constitution and said that now make us a university or deemed to be the university because we established ourselves. We established this institution. And we have maintained its independence. We are administering it without any outside interference. In this context, please see page 4, Lord, section 28. J, Lord, ground J. Both the ordinances and the statutes, Lord, these are the administrative governance documents. A will have some powers, B will have some powers, C will have some powers, and Pune will have some duties. Powers coupled with duty for everyone. That would be decided by ordinances and by the statutes. Correct, Malord? That's the administrative structure substantially provided as a substantive provision in the Act. Statute could not have been amended without approval of the Governor General in Council. The power in this regard was so wide that the Governor General in Council could reject the amendments proposed by the authority of the authorities of the university. The relevant provision are section 28(2)(c) and 33. Lord, please read this. No new statute means after the first statute which were made by the Imperial Council. No new statute or amendment or repeal of an existing statute shall have any validity until it has been submitted through the visiting board, Lord, completely non-Muslim visiting board, which may record its opinion thereon to the Governor General in Council, and mark this word, my lord, and has been approved by the latter, who may sanction, disallow, or remit it for further consideration. It never was.
Yes, Mr.
Yes. So the governance document that registrar will do this, deputy registrar will do this, joint registrar will do this, court master will do this. I'm just giving a hypothetical example. And peon will do this. That is the document. That governance document, which is the documents of administration, there is no power in the court, exclusive power with the court. The Governor General in Council would say that no, this is not acceptable. So similar is the position with ordinance. No new ordinance or amendment or repeal of an existing ordinance shall have any validity until it has been submitted to the court and the visiting board, which may record its opinion to the Governor General in Council and has obtained the approval of the letter, who may sanction, disallow or remit it for further consideration. My Lord, the respectful submission is, as on 1920, it was neither established nor was being administered by the minority, and therefore their claim post-constitution would not sustain. Lord, I can say Mao, if would have remained Mao College, could have raised the claim after the constitution.
Suddenly said Mao, I said, where does Mao come from?
No. MAO, my Lord, I'm sorry, not
Yes.
No, not Mao Zedong. No, I'm sorry, my Lord. Mohammedan Anglo
Yes.
Oriental College.
In a lighter sense.
Your Lordships are right. That college could have raised, not could have, it could definitely have raised that we established it. We were administering it. We are a minority now post-constitution. Because before that constitution, there was no minority concepts. There were, all of us were subjects, Hindus, Muslims, Parsis, Sikhs, Jains, everyone. Now, we have been doing it. That's what, my Lord, the St. Stephen did. St. Stephen did that, my Lord. And
Right, now we've seen this note on
now
administration.
please
What
see,
is the next point?
post-constitution, my Lord, I have given the chart.
Which is that chart? Post
Lord, page 5. Page 5. Post-constitution, after taking into consideration all amendments, my Lord, as it stands today, as AMU stands today, is there any administrative control? Because, your Lordships, it is not disputed that word "and" will have to be read as "and" only. Established and administered, not "or." It's not their argument also. Now, my Lord, Chancellor need not be a Muslim under the new act. If de facto governor appoints him, doesn't make the legal difference. Lord, kindly see, my Lord, if
How many chancellors have been non-Muslims actually in the case of the institute?
we have not examined, my Lord, but possibly all were Muslims. That's the convention. I am on law. 23 or 25 so far. So, my Lord, de facto status would not change the legal position. My Lord, for example, Lord, suppose there had never been a lady attorney general. That doesn't mean that it has to be a man. It incidentally happened to be a man.
That argument may be slightly different. That argument.
But I'm giving the
that
example
not
may be
be a-
different.
That would be a correct argument.
Lord, example may be a different, my Lord, example,
But when we are examining whether what has been the history in the past, whether administration can be only judged on the basis of what has happened and what has been actually after in last, how many, 1920 till we almost now going to be completing 100 years in another 3 years?
103 years, yes.
150
I
years.
just
We have
answer
completed-
that question.
Any time in the past where the chancellor, pro-vice chancellor, vice chancellor have been non-Muslims?
My Lord, I'll check up and say, but not to my knowledge. Possibly they were Muslims.
And why
I
is
must be
it then
fair.
that governments, both before the advent of the
Lord, I'm told
constitution,
4 were non-Muslims, my Lord. 4 were non-Muslims.
but why is it that before the advent of the constitution and post the constitution, the predominant choice of chancellors by successive governments has been of Muslims? That's certainly one factor which has to be borne in mind.
Lord, can by government appointing a particular community, though the law does not require it to do, change the character of that university, my Lord?
It may
That
be
the
a
government
recognition.
keep on appointing Muslims.
Equally,
Irrespective of Article 30, it's not established or
equally, as
administered.
you rightly said, that we have to look at it in a holistic perspective.
Yes,
Could it possibly be a recognition of the fact by successive governments that this is how they have been perceived at an administrative level
well, then
by
they
the
would
university itself?
Well, then they would not have required 81 amendment. If that was the interpretation, that is how it was being given, I'll come to, my lord, the periodical interpretation. Why I say, my lord, it need not be a Muslim, there is a reason. Your lordships have seen the provision of court, where there was a provision that all members shall have to be Muslim. That's the legal provision your lordship would bear in mind. Here it doesn't say the chancellor will have to be Muslim. Incidentally, it was a Muslim, he was a Muslim, he or she is different thing. That would not change your lordship's, my lord, adjudication whether this has a minority status or not.
There's one more thing. Suppose, let's assume it's a minority institution
Yes,
in a case. The minority institution appoints a non-minority as the vice chancellor or chancellor. Will it make it non-minority?
it cannot. My lord, Saint Stephens, reverse, your lordships are right. Saint Stephens do not always appoint, my lord, principal from the Christian community.
Fairly speaking, therefore, when we look at the term administration, we'll have to take into account how actually it is administered on the ground.
The legal position, not de facto position. The legal position. My lord, in case of Saint Stephens, my lord, it is never that only Christians were appointed as principals. Then it's bad. That's not the concept of a minority institution. But Lord, my point is, your lordships will go by the statutory provisions.
Because our law recognizes the power of the minority to appoint the head of the institution. No outsider can be foisted. You may choose somebody else. You may have a distinguished nuclear scientist who is not a minority. But
Ideally
that's a
not.
choice.
I'm
The element is not.
not saying
The
legally
element
wrong.
is the choice.
I'm not saying legally wrong. You should not confine the benefit going to the students to one community. There may be many other eminent people, may not be belonging to a particular community, who can take the institute to a further height. But you can't deprive the students of that. That's what as an ideal position, not legally, it is wrong.
Okay. Article 30 in the end uses the word choice. If by choice, a minority institution agrees to abide by certain terms and conditions in order to establish itself and get certain, say, a degree, will they lose that by choice if they do it? Will they lose their minority status?
It is a minority,
It is a minority institution.
undisputed minority.
Yes. By choice, they agree to certain rules and regulations and even administrative overall supervisory control. Will they lose their minority status?
Not after the constitution. If it is established after the constitution, no. My lord, for example, take a flip side.
Why should
Take a
that-
flip side, my lord.
Once you accept that, then why not before the constitution?
My lord. My lord,
Because once you accept, then the administration
Take
is
a-
with them.
my lord, take a flip side of it. My lord, suppose in Banaras Hindu University, as a tradition of a gesture of goodwill, the government continued, my lord, had continued. I'm giving an hypothetical example. Only Muslims are vice chancellors and Muslims in the position of power. Would it come, and I'm posing a question to myself, would it convert itself into a minority institution? If what example, my lord, we are discussing is true, the reverse also has to be true. If de facto can change the de jure position, then, my lord, it should apply to everyone. And, my lord, there are some benefits to a minority institution. From tomorrow onwards, my lord, some institution can start converting itself into a minority by merely appointing people. Though law doesn't require, the statute incorporating it may not require. Well, all British, my understanding is right, all British authorities were Christians in those days. So, my lord, de facto, what is the position is, in my respectful submission, irrelevant. It may be a practice, it may be a political stand of the government, it may be, my lord, for various reasons. as the, my lord, in the initial Britishers also were requested that please, izzat ke liye, but that's the word which is used. Take into account our feelings and have Muslims. Maybe that's the reason. But that doesn't define the character of the institution. But therefore I say, the way God mandates only consisting of Muslims with the provision
Let's
now.
quickly run through this chart so that we can go on to the next
Here,
one.
my lord, when I say need not be Muslim means the law doesn't require him to be Muslim. He may be Muslim, he may be any other religion. Chancellor need not be Muslim, pro-chancellor need not be Muslim. My lord, throughout, I'm not reading it, up to proctor need not be Muslim. Then representatives of the department and colleges need not be Muslim. Some expert, my lord, in a chemical engineering branch may be sent as a member, my lord. He may not be Muslim. He may happen to be a Muslim, but the law doesn't say that a representative of department of colleges belonging to Muslim community. That's not the law. Need, therefore, my lord, I am carefully using the word need not be Muslim.
Okay, this, the chart in X-ray is pre-1981 or post-1981?
As on date, as it stands.
And what was the position pre-81?
Lord, I have said, Lord, court is concerned, it was full Muslims. Till 51 amendment, it was deleted. 1951 amendment, which was deleted. I'll show, Lord, that comparative.
So this chart, this is as it exists
As
today.
it exists today. And as it exists today, my lord, if your lordships were to go, need not be Muslim. Lord, when I say, my lord, representative.
There may be slight problem in this because we have to deal with the, whether it's an institution which was minority or not, as on the date when the constitution.
Correct. This is irrelevant according to my submission.
So this 1981 amendment may not be so much, or post 1981
Yes.
may not be so much, because if it was a minor, you can, to that extent, there is no list of between the two sides. If it was a minority institution as on the date in 1950, then it will continue to be a minority institution.
Lord, the difficult.
Because they have challenged, some of them have challenged the 1981 amendment also.
Yes, that's the issue. That I'll come to that, my lord. And there, when the bill was introduced, it was introduced on the ground that Congress had that in the election manifesto.
There was
That was the ground. And there is a beautiful opposition by an eminent parliamentarian who was an eminent counsel of this court, Somnath Chetan, that you can't do this. This is not the way you take away basis of the judgment. I'll come to that. But my lord, there are only 35 persons who can be Muslims out of 189 as on date. Who can be Muslims, my lord, I am saying. Mandate, no mandate that they have to be Muslims. For example, my lord, representatives of alumni, past alumni. But there are all community students who are studying here. They have engineering college, management college, medical college, everything. Maybe other community people may represent that constituency of alumni. Two persons representing Urdu language, my lord, for example. He may not be a Muslim, my lord, but an expert in Urdu. There are people who are experts in Urdu. They can, my lord, be the representatives. So therefore, I carefully use the word need not be Muslim. The law doesn't require them to be Muslim. But 39, 35 people, 37 people may be Muslim. I am against, they also don't require Muslim. Please, my lord, come to page, my lord, page 8.
What is the reason to bring in representatives of Muslim culture and learning?
My lord, there is one of the subjects. The way, my lord, other subjects are taught.
Why do they at all have to bring in people who are representatives of
There
Muslim
is a
culture
small
and learning?
carve-out.
Or what is the need to bring in, say, representatives of the All India Muslim Education Conference? What is the genesis of that?
My lord, just, my lord, if your lordship sees, there are several subjects being taught. Lord, there is, my lord, a separate constituency, representatives of teachers other than chairman and department and principals of colleges. So they have representation. Chemistry will have a representation, medicine, biology, etc., etc. But one of the, my lord, subjects out of several is Muslim theology. and Muslim culture. Therefore, they have representation. But therefore, it does not say, the provision does not say they will be Muslims. Muslim Cultural Association will send 5 people. They may be Muslims. They may send others also. Look, therefore, I say what is required as per Kerala Education Bill is sprinkling of outsiders. This is not sprinkling of outsiders. This is predominant outsiders. If I may use that expression, nobody is an outsider, but predominant non-minority people. Yes, I'll now, my lord, come to, my lord, I'll just show the chart, my lord. My lord, the Chief Justice also, my lord, desired that there has to be on one page how the amendment took place. My lord, first in 51, 65, 72, 81. So we have prepared that chart. It won't take more than 5 minutes because we have depicted the amendment in different colors. So your lordship would get only in 5-7 minutes, my lord. The amendments.
Section 9 was amended in 51 or 59?
Pardon?
Section 9, that
51.
amendment, 51.
50. My lord, your lordships may see the legend on the top. Black is original act, my lord, as it stood. I'm sorry, my lord. What is in black is as it stood when the act was passed. Red is 51 amendment. Orange is 65 amendment. Gold is 1972 amendment. And green is 81 amendment.
All right.
Lord, the relevant would be, my lord, kindly see the green one, my lord, first, in 1981. An act to establish and incorporate a teaching, established and is deleted. My lord, with limited experience, my lord, I have come to know about such an amendment for the first time, where the preamble is amended, that it was not established. The historical fact is changed by making an amendment after about 60 years. And incorporation continues. So incorporation is also establishment. They possibly forgot, my lord. They established and incorporated. Now please, my lord, see
So
rest of the...
there may be an alternate reading also, which is that the amendment to the preamble is to bring the preamble in conformity with a historical fact. And in that sense, it is declarative.
Historical fact, my lord, cannot be changed, my lord, by...
They're not changing a historical fact. They're changing the provision of an act which was inconsistent with the historical fact. So as to bring it in conformity with the historical fact. I mean, there's an alternate reading possible.
My lord, kindly appreciate...
One more thing. This is the amendment by the parliament.
Correct?
And is the government accepting the amendment or?
I'm not.
How can you not accept it, accept an amendment by Parliament? Mr. Solicitor, Parliament is an eternal, indestructible body under the Indian Union.
Correct, my lord, and
And
continuing.
irrespective of which government represents the cause of the Union of
No,
India.
I'm not saying.
Parliament's cause is eternal, indivisible, and indestructible. And I can't hear the government of India to say that an amendment which Parliament made is something I don't stand by. You have to stand by this amendment.
Allow me to answer that, my lord.
You have an option. You go
Allow
through
me
the
to
amending.
answer.
You have an option. Go through the amending route and change the amending act
Allow
again.
me to answer that
That's
question.
ultimate power.
My lord, allow me to answer that question. My lord, I am not arguing a matter of A versus B. I am before a 7-judge constitution bench answering constitutional questions. That is number one. Number two, the amendment in question was subjected to challenge before the High Court, and there is a judgment declaring that it is unconstitutional for ABCD grounds. And as a law officer, it is my right as well as my lord, entitlement and duty to say that this view appears to be correct. And third,
Mr. Solicitor, this will be radical, because a law officer will be then telling us that I don't abide by what Parliament has done.
my lord, in that case,
You have to stand by what Parliament has done, but Parliament is supreme. Parliament is undoubtedly supreme in its lawmaking function. Parliament can always amend a statute, in which case the law officer can say, well, I have an amended statute now, which I am going to place
your
before you.
lordships expect
Can we hear any organ of the union government to say that notwithstanding a parliamentary amendment, I don't accept this amendment?
Lord, I am supporting the judgment. Lord, would your lordships, my
In
lord,
that sense, Parliament.
please allow me to answer this.
Parliament is, that's why I said, Parliament is an eternal, indivisible, and an indestructible entity under the democracy.
No, I am not disputing that, but, my lord, would you, I'm posing a question to myself.
How can you
Would
say
I-
that, look, I don't accept the validity of an amendment?
Hmm?
Or I don't
Lord,
accept,
Lord,
I
during
don't
emer-
accept that there was a ground for
Can
this
I
amendment.
answer? Yeah, it's more, my lord, one-sided there, my lord. Can I answer that? Would a law officer be expected to say that whatever amendments were made in the Constitution of India during emergency were true only because they were made by the Parliament? Here, I have a judgment of the Supreme.
But Mr.
Allow me
Solicitor,
to complete.
that's why the 44th
I
amendment
will not
came
raise
in.
that point, my lord.
That's why the 44th amendment.
Let others
came in.
argue, my lord. If that is so, my lord, I will not raise that.
If the 44th amendment came in only for that, the 44th amendment came to redress the evils which were perpetrated in the name of a constitutional
Who will
amendment.
decide, my lord, that these are evils being perpetrated?
Obviously, exactly, you prove my point. The power to decide that is in the elected body of the people, which is Parliament.
My lord, there is
Parliament can always say that what we did during the emergency was wrong and we are rectifying it by
Lord,
the 44th
not
amendment.
after it is set aside by the division bench of a high court, my lord, and therefore it is not on the statute book. And when I am not in A versus B situation, I am in a constitution bench answering a legal proposition, whether such a thing can be done or not. And if I do not do, and there is an affidavit filed by the government, it's not my stand, it could have been my stand also. But if I cannot argue, my lord, that this amendment could not have been made, I will have to support, any law officer will have to support every amendment made during emergency, irrespective of, my lord, whether it is my view or anybody else's view, that this was to remove some anomalies or some bad things happening to the citizens of India. I'm sorry, please don't make it a political thing. Please don't do this. Then don't interrupt. Then don't do it. Then don't. You say don't. I don't want to interrupt, and then you interrupt.
Ability in court, please.
My lord, I am sorry, my lord. Your lordships would come in. Your lordships would come in.
Let's not,
Your lordships would come in, my lord.
Let's 1 second.
No, my lord. Here,
1 second, Mr. Let's not allow the pristine character of the dialogue to degenerate.
I'm
1
yes, my
second.
lord. This is
All right. We'll give you
unacceptable.
1 second. We give you 30 seconds to make a point of law, not on personally on the Solicitor General. Let's keep out personal, yes, just
I was
30
in
seconds.
court on the day when the emergency argument was, I was only going to make a historical reference for us. I was sitting in court when the Attorney General of India, Niran Day, was standing here and arguing that what has been done is right. I defend the emergency provision. Why? Because he could not say otherwise. It's only that I'm saying. But I was not going to say anything against him.
Yes.
I don't know why, but
No, my lord, you did say something. You used an uncivilized word which is not used in the court, and you generally do not use, maybe infected as of now. But, my lord, I'll say, your lordship, the distinction is, Niren Day was not, my lord, in a situation where one high court had struck it down and the provision was not on the statute book.
yes, the
Here-
Madhya Pradesh High Court had struck it down.
9 high courts.
Yes. What do you?
There were other high courts which have upheld, and there is all your lordships are aware, Mr. Niren Day told the court that if somebody is hanged, can we not do anything? Yes, he said, yes, we cannot do anything. It was not to defend it. It was to instigate the judges that please interfere. This is the position. Lord, everyone knows, my lord, there are two versions. When Mr. Niren Day, the learned Attorney General, then told the court, when the court asked, do we not protect Article 21 if somebody is being hanged or his personal liberty is deprived? He said, yes, you cannot do it. It was not to defend the act. It was to instigate the court that this is the position. Please interfere.
Mr. Solicitor General, let's come back to the point. Your
Yes.
argument is that 1981 amendment, you need not to comment for the simple reason that by virtue of a judicial verdict, this provision has been erased from the statute book.
Correct.
That is what you want.
It is,
So we
it
can
doesn't
now-
exist as of now. I leave it at that, my lord. I will not, my lord, be uncivilized in my, my lord, arguments. Now, my lord, please come to Mr. Sibal is generally not, my lord, but then, my lord, please see, my lord, 51 amendment first. My lord, 51 amendment is at page, my lord, section 8, my lord, please see section 8. It is made, my lord, this is post-constitution. The university shall, subject to the provision of this act and the ordinances, be
Section
open.
8, Section 8.
8. Read is 51 amendment, my lord. The university shall, subject to the provision of this act and the ordinances, be open to persons of either sex and whatever race, creed, caste or class, and it shall not be lawful for the university to adopt or impose on any person any test whatsoever of religious belief or profession in order to entitle him to be admitted therein as a teacher or student, or to hold any office therein, or to graduate thereat, or to enjoy or exercise any privilege thereof, except in respect of any particular benefaction accepted by the university, where such test is made a condition thereof by any testamentary or other so and so, so and so. Now, my lord, please see.
Provided that nothing in this section shall be deemed to prevent a religious instruction being given in a manner prescribed.
Yes, my lord.
By the
To prevent religious instruction being given in the manner prescribed by the ordinances to those who have consented. My lord, this is 28.
Yes.
Article 20.
Just now, and now come to 28, Article 20. Just have.
28, my lord, yes.
23.
But, my lord, I must tell your lordships, this is not under challenge. Instruction shall be provided in any educational institution wholly maintained out of the state funds.
Now, in 1951, this was a religious, this institution was maintained by, wholly by state funds?
My lord, may not be done, may not be wholly.
No, wholly we'll have to exclude small little fees, etc. But it was,
Otherwise, yes.
it was wholly.
Yes.
Yes, in fact, it is your argument that.
Yes,
it was
yes.
wholly.
They were having some minor.
So there is a bar on providing religious instructions in institutions wholly maintained by state fund.
Correct.
2.
Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution.
So the exception carved out here?
Yes, this
Where
is,
it is administered by the state, but establishment is by the religious institute, it's a trust or endowment which is established, there the religious instruction can be given.
Yes.
Now read 3.
no person attending any educational institution recognized by the state or receiving aid out of the state funds shall be required to take part in any religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such person or if such person is a minor, his guardian has given his consent thereto.
Okay, according to you, as on the date when constitution was enforced, which part of Article 28 will apply? Which clause of Article 28 will apply?
No, 3.
Not 1 and 2?
1 and 3, but 2 may not apply, 1 and 3.
1 applies, then is it possible for that institution to grant or permit religious instructions?
One is absolute, my lord, that's what your lordship said. It may not be permissible, my lord. As the constitution reads, my lord, it may not be permissible. But, my lord, possibly it.
Then when we, the the 1951 amendment, which is in terms of three. To give an option, when you say three applies, indirectly you are accepting it as a minority institution. Because three only applies to minority institutions.
No, my lord.
Yes. No, not sorry. It applies to non-state funded institutions, only non-state funded institutions.
Yeah.
You're right to that. Yes.
So, my lord, but in any case, this is not.
Or in case of state funded institutions, which are minority institutions, three obviously will apply.
Now, my lord, section 9 was deleted, my lord, if your lordship sees, my lord. Section 9, my lord, which required, please see, my lord, 9, original act. The court shall have power to make statutes providing.
Let's go back to Article 28 and the proviso to section 8.
I'm sorry, my lord, I was little taken.
We'll just go back to the proviso.
No, I was on the last point, my lord. My apologies, my lord. But I genuinely feel I can and I will. 81. The 81 amendment, my lord. My apologies for that.
No, the 81 amendment, let's see section 8 for a moment. We were looking at section 8 at your on
yes.
that page.
As it stood, my lord?
No, after the 81 amendment. Because the 81 amendment is in red.
No, 51 is in red.
Sorry, I'm sorry. I meant the 51 amendment. The 51 amendment is in red.
Correct.
Now, what the 51 amendment does is introduces the proviso, provided that nothing in this section shall be deemed to prevent religious instruction being given in the manner prescribed by the ordinances to those who have consented to receive it.
Correct.
So it expressly allows for religious instruction in AMU, subject to the consent of those who are receiving religious instruction. Now, under what provision of Article 28 does this proviso to Section 8 fall? If you look at the first clause of Article 28, the first clause of Article 28 interposes a complete bar, right? See Article 28(1).
No religious instruction shall be provided in any educational institution wholly maintained out of the state funds.
No, it is maintained out of state funds. For a moment, we'll take it on the basis that it is wholly maintained out of
Correct,
state funds. So, any form of religious instruction would especially be barred in AMU by virtue of the provisions of Article 28(1). Now, Article 28(2), Clause 2 lifts the bar to a certain extent.
Except
Right?
for two exceptions.
Right.
Yes.
Now, where does it lift the bar? Let's read 28(2). Nothing in Clause 1 shall apply to...
I'll read, your lordship. Shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution.
And now what does 3 do? That no person who attends such an institution, a state-aided institution, will be compelled to undergo religious instruction unless the parent or guardian has consented. This puts the requirement of consent. So clause 2, then otherwise there would have been an absolute bar under clause 2, Article 28(1). What clause 2 of Article 28 does is to lift the bar. In the case of an institution which may be otherwise administered by the state, but which has been established under an endowment or trust which requires that religious instruction shall be imparted in such institution. So,
the 2 doesn't apply in fact.
Proviso, perhaps, the proviso to Section 8 is in recognition of, is an implementation of the provisions or is pursuant to the provisions of Clause 2 of Article 28. But for Clause 2 of Article 28, that proviso would have run afoul of Clause 1 of Article 28. So that proviso comes in as a result of Clause 2 of Article 28. Now, when it comes under Clause 2 of 28, it's a recognition of the fact that this is established by a trust or endowment, which requires that religious instruction has to be given or imparted in such institution.
So the government is kind of bound by the covenants of that, my lord, trust or endowment.
Or trust.
Yes. Another thing, 2 has no relevance. It's a different fact. Twenty-eight. Lord, one, Lord, my respectful submission is that even if there is some, Lord, some internal generation of money, possibly one may not apply, but that situation we are not facing. Here it would be 3. That is why section 9 is deleted. Number 1. Number 2, 28 is
No,
agnostic.
what it permits is, what the 51 amendment permits is, you can impart religious instructions in this institution.
Yes. And,
Religious
my lord,
in
important.
education in this institution. So indirectly, they are saying that one will not apply. Now, one may not apply if the institution falls under Article 30.
No, not necessarily.
We'll have to harmoniously interpret Article 28 and Article 30.
May I, my lord, answer that question, my lord? Lord, may I give one more? Yes, sir. Hmm.
Yes, yes, yes. We will. We will.
Lordships can, my lord, at this stage examine. 28 is an agnostic provision. It applies to minority as well as non-minorities.
Correct?
So even if it is a minority institution or non-minority institution, one says
It
if it is wholly,
It introduces the character of secularism in education.
yes. And three kinds of take a middle path that all right, if you wish to, you provide, but don't compel. And even in case of a minority, my lord, academically and constitutionally, it is possible that a minority institution, say Hindu, the Muslim minority institution, may say that we will provide religious education both in Hindu studies and Islamic studies. So what they cannot do, they cannot compel the students. So it is, my lord, the
Three is a provision which is against compulsion. What 3 does is basically to create an option. That's why 9 came to be deleted, really speaking in that sense.
exactly, I'm obliged.
9 was deleted. Because
Simultaneously.
9 provided for compulsory religious instruction to Muslim students.
Yes, therefore.
Now, after the deletion of 9, it's not that religious instruction is done away with, but all students, Muslim or otherwise, have now a choice.
There may be therefore an exception to both 1 and 2. Read it carefully.
Another very important aspect of 3 is 3 applies even if you are not wholly maintained out of state funds. Because 3 merely says receiving aid. Receiving aid may be 5%, 10%, whatever. Once you are receiving any aid, then 3 applies.
Or,
1 applies, 1 is wholly out of state funds.
so meaning thereby, if you have a madrasa or a gurukul, for both, what I'm saying, without receiving any aid, you impart religious education, not a religious instruction, no difficulty. But the moment you start accepting something from the government, constitution steps in, and whether,
This will be important. Just read 3 once again.
yes, madam, no person attending any educational institution recognized by the state
So 1 requirement is recognized by the
Recognized.
state. Number 2 is,
or receiving aid out of the state fund shall
now
be.
here the words are not used wholly funded by the state.
Correct, Manoj, yes.
Any aid received by the state.
Not
So
wholly.
If not wholly. So if we read it as an exception to 1, then it may be permissible even for wholly funded state institutions to impart religious education.
Not wholly.
You're not accepting that position. Your position is if it's wholly funded by the state, then number 1 apply, clause 1 will apply. Be careful what you're saying. It may have repercussions.
Actually, clause 1 imposes an absolute bar. Right?
Correct.
That if you are funded wholly out of state funds, you cannot have a religious instruction at all. That's clause 1. Clause 2 lifts the bar, which is evident from the use of the words nothing in clause 1.
One, it's an exception to one.
It's an exception to 1. Now, what 3 does is 3 imposes a requirement when you are receiving any aid, or of course recognition. You're not in the recognition aspect right now. So 3 is conditioned if you are receiving any aid, even if you are receiving 5% aid or 1% aid from the state, 3 applies. And what does 3 say? 3 says is that you can have religious instruction, but you can't make it compulsory. Unless, in the case of a minor, the parents or the guardian consent. Therefore, 3 in that sense, 1 applies only where you are wholly funded by the state. Even if you are not wholly funded by the state, you cannot compulsorily have religious instruction, which therefore means that if you are not funded by the state, you can make religious instruction compulsory. There's no difficulty. If you are funded by the state, whether wholly or in part, at the least, if you are funded in part, you are receiving any aid, because it says receiving aid. If you are receiving aid, you cannot have compulsory religious instruction. That's the purport of.
That's the middle of the way. Then if somebody wants,
But if you are wholly funded by the state, you cannot have any religious instruction at all. That is
even
one.
with consent. Even with consent.
Even with consent.
Is that the stand?
Even if you are not receiving,
Pardon?
aid, but if you are a recognized institution,
Yeah, and
you cannot come.
And recognized. So if it's either way, if you are recognized, but you're not receiving aid from the state, you cannot have compulsory religious instruction.
No, but therefore, if we accept your position, if it's a non-minority institution, can they impart religious education?
So, yes, subject to 28(3).
But then 28(3), as per the stand taken by you, will only apply to non-fully funded institutions.
So a non-minority institution which does not receive any aid, you can have compulsory religious instruction.
Yes, no, like you.
But even if you're a non-minority institution and you're receiving any aid from the state, you can't have compulsory religious instruction.
Correct. And
So
therefore, 9 is
28 applies. 28 is agnostic to whether you belong to the minority or otherwise.
correct.
28 applies
No,
across.
that's not TMFI also recognized.
Minority or non-minority.
As Brother Suryakant says, 28 draws no distinction between whether you are a minority or non-minority.
No, that's what I say. 28 is agnostic provision, whether you are minority or non-minority. It is
Also because 28 occurs in a subtitle or subpart
Exactly,
called
Manoj.
right to freedom of religion.
Yes,
that
Manoj.
applies to everybody.
29 and 30 only talks of minority.
Cultural and educational rights.
Yes. And 29 and 30 only uses the word minorities.
Institution.
I can always support. Other people. Necessary for the reason that 51 amendment is not under challenge.
No, we are interpreting.
Yes.
We are just interpreting. We are not going into the merits or demerits of 51
Yes.
amendment, but the impact thereof. You see, if we accept this argument,
Well,
then it will
therefore,
be a minority institution which is fully funded by the state cannot impart religious education.
correct. And
And in spite
once,
of Article 30, Clause 1.
Lord, once section 9 is deleted, compulsory education in to Muslim students, look, whatever limited minority status was there, that also went in 51. Compulsory education,
On Article, Clause 1 and 3 of Article 30, 28.
no, TMFI, Lord, I'll just read.
Does it deal with that issue? Question.
Yes, Lord, kindly see, Lord, page, this is 5A, para 144, page 651, Lord. 651.
Not there in this document.
There, the context was little different, but 28 is discussed. But my respectful submission would be in facts of this case,
Has this legal provision been interpreted? The Article 28 been interpreted?
yes. Yes. Lord, please see, page 140, para 144, my lords have. Lord, page, volume 5A, page 651. The discussion in 11 judge bench judgment of TMFI, about 28. My Lord Justice Mishra and Justice Padiwala. May I read, my Lord, para 144. It cannot be argued that no conditions can be imposed while giving aid to a minority institution, whether it is an institution run, this is post-constitution,
What page number?
651. Please kindly bear in mind, this is post-constitutional scenario.
Yeah.
The earlier conditions can be imposed. The Britishers were not bound by 30 or any other fundamental thing. It cannot be argued that no conditions can be imposed while giving aid to a minority institution, whether it is an institution run by the majority or the minority. All conditions that have relevance to the proper utilization of the grant in aid by an educational institution can be imposed. All that Article 30, Sub-Article 2 states is that on the ground that an institution is under the management of a minority, whether based on religion or language, grant of aid to that educational institution cannot be discriminated against. If other educational institutions are entitled to receive the aid, that's Article 14, my Lord. The condition for grant or non-grant of aid to educational institutions have to be uniformly applied, whether it is a majority-run institution or a minority-run institution. As in case of a majority-run institution, the moment a minority institution obtains a grant of aid, Article 28 of the Constitution comes into play. When an educational institution is maintained out of state funds, no religious instruction can be provided therein. Article 28(1) does not state that it applies only to educational institutions that are not established or maintained by religious or linguistic minorities. Furthermore, upon the receipt of aid, the provisions of Article 28(3) would apply to all educational institutions, whether run by minorities or non-minorities. As
So really speaking, right, and therefore the court says that 28 applies both to minority and non-minority institutions. 28 applies to both.
provision, because right now we are in the mental framework of religious
28,
minority.
once you receive aid or you are recognized within the meaning of 28(3), then the provisions, 28(1) applies once you are wholly funded by the state. And 28(3) applies whether you are receiving part aid or full aid or whether you are recognized. Then 28(3) the bar comes in, that you cannot compel religious instruction. That's the... And it is not as if 30 overrides 28. The prescription in 28 applies to minority institution as well.
As well. Lord, kindly.
Page number?
DMA5.
Which page number?
This page is.
What is the page number?
550.
This is 626.
626.
626.
626. And that would while Article 28(1) and 28(2) relate to your lordship's got that. While Article 28(1) and Article 28(2) relate to institutions that are wholly maintained out of the state funds, Article 28(3) deals with an educational institution that is recognized by the state or receives aid out of the state funds. Article 28(3) gives the person attending any educational institution the right not to take part in any religious instruction, which may be imparted by an institution recognized by the state or receiving aid from the state. Such a person also has the right not to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such a person is, or if he or she is a minor, his or her guardian has given his or her consent. The reading of Article 28(3) clearly shows that no person attending an educational institution can be required to take part in any religious instruction or any religious worship unless the person or his or her guardian has given his or her consent thereto. In a case where the educational institution has been recognized by the state or receives the aid out of the state funds. We have seen that Article 26A gives the religious denomination right to establish an educational institution, the religious denomination being either of the majority community or minority community. In any institution, whether established by the majority or a minority religion, if religious instruction is imparted, no student can be compelled to take part in the said religious instruction or in any religious worship. An individual has the absolute right not to be compelled to take part in any religious instruction or worship. Article 28(3) thereby recognizes the right of an individual to practice or profess his own religion. In other words, in matters relating to religious instruction or worship, there can be no compulsion where the educational institution is either recognized by the state or receives aid from it. Article 29 and 30 are a group of articles relating to cultural and educational rights. Article 29(1) gives the right to any citizen of a section of citizens residing in India or any part thereof and having distinct language, script, or culture of its own to conserve the same. Article 29(1) does not refer to any religion, even though the marginal note of the article mentions the interest of minorities. Article 29(1), it can be not linguistic. 29(1) essentially refers to sections of citizens who have a distinct language, script, or culture, even though their religion may not be the same. The common thread that runs through Article 29(1) is language, script, or culture and not religion. For example, if any part of the country, there is a section of the society that has a distinct language, they are entitled to conserve the same, even though the persons having that language may profess different religions. Article 29(1) gives the right to all sections of citizens, whether they are in minority or majority religion, to conserve their language, script, or culture, etc. But I may read further. But for example, Gujarati being a linguistic minority in say Delhi, may provide for an institution, and it may have people from Muslim community, Hindu community, Parsi community, all speaking Gujarati language. So what is binding is the linguistic minority character or some kind of a culture. That's what 29 provides.
But Parsi Gujarati is very different from Gujarati Gujarati.
That is true. That is true.
A little more colorful also.
Sometimes extra colorful. So, the Parsi abuse doesn't feel like an abuse. They abuse it in such a way, my lord, that lovingly. Your lordship knows, my lord, my lord says the experience.
Abuse loving people.
What?
I said Gujarati notes.
I don't bring, my lord.
No, but,
I am not a man in anyway, my lord. I'm my lord, just.
Time two may also be there. It's important.
29(2).
No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state funds on grounds only of religion, race, caste, language, or any of.
So we have now examined the we have examined the 65 amendment, 51 amendment. Now we go to the 65 amendment.
Yes.
That is the Orange amendment, right?
Yes.
Orange is basically in section 23, the 65 amendment.
Yes. There is no other change, my lord.
Only
There are some
23.
changes, my lord, in, no, there is none.
I think 23. Just let's see what happens.
23, my lord, the court. The court shall consist of the chancellor, the pro-chancellor, and the vice-chancellor for the time being, and such other persons as may be specified in the statute.
Then subsection 2 is deleted.
Is deleted. The court shall be supreme authority, etc., etc. Please turn the page, my lord, over. And it is given, my lord, advisory function. In accordance with, I'm sorry, my lord, statutes. My lord, the functions of the court shall be to advise the visitor in respect of any matter which may be referred to the court for advice, to advise any other authority of the university in respect of any matter which may be referred to the court for advice, and to perform such other duties and exercise such other powers as may be assigned to it by the visitor or under this act. Lord, this
was a 65 amendment.
was 65.
What happened in 72? Anything substantive in 72 or?
Yes, my lord. Lord, please come to, my lord, section 23 only. Lord, there is no major change, my lord, in other aspects, except, my lord, some powers of the Vice Chancellor are improved. But 23 in 72 Act, the constitution of the court and the term of office of its members shall be such as may be prescribed by the statute. Subject to the provisions of this act, the court shall have the following powers and functions: to review from time to time the broad policies and programs of the university and to suggest measures for the improvement and development of the university, to consider and pass resolutions on the annual report, annual accounts of the university and audit report thereon, to advise the visitor in respect of any matter which may be referred to it for the advice, and to perform such other functions as may be prescribed in the act.
Sorry. Look at the original act 17 and 18 also. 17 and 19.
Yes, ma'am. Now, please come to 17.
There's some provision in 19.
Chancellors shall be elected by the court.
Yes, ma'am. No change in 51 and 65.
Now,
72, they made that change in
Yes,
bold.
no, the chancellor shall be appointed by the visitor in such manner as may be prescribed by the statutes. The chancellor shall, by virtue of his office, be the head of the university. The chancellor shall, if present, preside at convocations of the university
that's
held.
not relevant. That's not right. But what is relevant perhaps is that prior to in the original enactment, the successor to the chancellor shall be elected by the court.
Court. Now.
And number two, vice chancellor also, the successors to the first vice chancellor shall be elected by the court amongst its members.
Yes, ma'am.
After the amendment, they will be appointed by the visitor.
By the visitor.
But such appointment shall be subject to the approval of Governor General and Council. Vice Chancellor is concerned.
One very interesting amendment which was made in 1972, come back to section 5.
Yes.
See 5(2).
Yes.
University shall have the following power. 5(2) was to promote Oriental and Islamic studies and give instruction in Muslim theology and religion, and to impart moral and physical training.
This was original.
He now comes in.
Yes.
He says to promote the study of religion, civilization and culture of India.
Of India, not one religion.
Becomes more secular in its
More
form.
secular.
And then comes
thereafter-
81. And then comes 81.
Yes, Lord, please come to
is green,
81.
right?
Lord.
Green is 81.
Lord, definition clause. Please come to the definition clause. This does not stand as of now, my Lord. It's set aside. L, my Lord. 2L.
University.
Yes, university means Aligarh.
Just one.
Lordships have 2L, my Lord. Lordship, see. L.
Yeah.
University means, Lord, originally it was Aligarh Muslim University. The educational institution of their choice, established by the Muslims of India, which originated as the Mohammedan Anglo-Oriental College, Aligarh, and which was subsequently incorporated as the Aligarh Muslim University.
What the amendment of 1981 did was to squarely sort of give it a minority status. That was the object. Because two things they did. They deleted the word established from the preamble, and in the definition of university, they now take it, it's a recognition that, well, this was established by the Muslims of
Whether
India.
that can be done or cannot be done is a subject.
No, that's a separate issue.
That's a separate issue. That's
But
what they did.
What
Yes.
was the purport of the amendment?
Yes, that's what they did. Parliament did not.
Freedom seek.
Solicitor, it's well settled that the legislature, whether it's a state legislature or parliament, can take away the basis of an act of the basis of a judgment. So, for instance, if a judgment holds a statutory provision to be violative of Article 14 on the ground that it does not comport with natural justice, the legislature can introduce a provision for natural justice so as to make it in conformity with the law by supplanting the deficiency which was noticed by the judgment. So what you can't do is to directly override a judgment, right? So, for instance, the classical case was Madan Mohan Pathak, where there was a binding settlement, an industrial settlement, on which a mandamus was issued by the Supreme Court. That settlement was sought to be overridden by an amending provision, which the court held this you can't do because it has attained finality. Now, what does 2L do? 2L, or before we go to 2L, what did Basha do? Basha said that AMU was not established by a Muslim minority, but was established under an act of the imperial legislature, right? And it is administered not by the minority, but is administered by this institution, by the act. Can by merely an amendment to the definition, can you take away the basis of Basha? Because
Lord, my
what
legal
2L does, possibly what the argument, and this we may have to hear the other side in response because this was not argued in the opening, that 2L merely alters the definition of the expression university. But does the alteration of the definition of the expression university take away the basis of Basha? That the very establishment, now what the 81 amendment does is, it doesn't purport to establish the university at all. Now, it says that the word establish is taken away from the preamble.
But incorporated remains.
Incorporated remains. Then 2L says that it was established by the by the Indian Muslims of India, originating as the MAO College Aligarh,
Correct.
and which was subsequently incorporated.
The argument rejected is in Bhasha is incorporated by way of a definition.
Now, is this amendment, by the way, in 81, is it retrospective or is it prospective?
Lord,
Lord, our argument before the Allahabad High Court is it's declaratory in nature and therefore retrospective.
Necessarily retrospective.
That was the argument.
Lord, I don't wish to give examples, but if you can change history by changing definition in a statute, your lordships can, with your lordships' wide experience and wisdom, visualize, Lord, what can be done. There are several historical facts, my Lord.
No, Parliament can do it.
May, my Lord,
But
Parliament think of
Parliament
change.
has the power to do it. Parliament has the power to do it. Because Parliament can, while implementing a statute, subject to a challenge under Article 14, Parliament can...
Competence, yes.
It has the competence to say this
But
is our
whether
view
it
when we enact
amounts
the law.
to effacing
Certain-
Bhasha or not, that's a question.
That the more important substantive point is this really declaratory as they are arguing? Or are you merely amending the definition without taking away the basis of Bhasha? The latter you cannot do. The former you can do.
You can't sit in appeal. The Parliament cannot sit in appeal and set aside the judgment. It can, if there is some lacuna found by the court, that lacuna can be filled up. But, Lord, it is my submission and
Bhasha said that AMU was not established. Says AMU was not established by the Muslim minority,
intra-party dispute
but
is
it was established under an act of the imperial legislature. Thus, can merely an amendment to the definition of the expression university take away that basis of Bhasha?
And, my Lord, their argument that it was established by the educational institution of their, by Muslims of India, which originated
Because
at
to take away the basis of Bhasha, you have to take away the underlying facts on the basis of which Bhasha has been decided. Have they really altered those underlying facts by this amendment?
I requested your lordships that I would like to read Bhasha the way I request your lordships to read. Bhasha doesn't say what they are apprehending. Bhasha is a sui generis Aligarh University case. And it defines and records certain factual findings also, which, my Lord, this amendment of the Parliament seeks to do away with.
Is there an alternate reading not possible? I mean, we are discussing various options. I mean, we just because the idea, it's not an easy, it's a thorny issue. The original act said the university is established and incorporated under this act. The preamble says established and incorporated. Right? Suppose established was not there and it had merely used the word and incorporated under this act.
Only incorporated.
In which case, it would have been established by whoever it had been established by, but it was given a statutory form of a juristic personality by the original Act of 1920. Now, Bhasha relied heavily on the preambulary provision, which says established and incorporate. That means you are setting it up for the first time by the Act of Parliament.
Even incorporation would
Is
be
it not
setting
open-
it up for the first time.
No, that may be a little different because incorporation is giving it a juristic form. Establishment is an establishment in fact. But is it open to Parliament? Or put it the other way, is it not open to Parliament to say that, well, Bhasha relied on a statutory provision, namely the word established, to hold that it was established under an act and not by somebody divorced the statute. We will amend the statute to take away the word established so as to make it clear that our intent is that this was only given a juristic form by the Act of Parliament.
Can the
Can
intention
Parliament not
of
do that? Can Parliament not do that?
Lord, can the intention of the Parliament as it existed in 20 be supplemented or amended that this was the intention?
That you
after
can always do. There's no, Parliament's power is untrammeled.
Let that be argued. Lord, they were not comfortable in arguing this point.
In,
They said, let it go to the regular bench. I am ready to argue. This is set aside by the division bench of High Court by a
Parliament does
reasoned
that
order,
all-
I'm ready to
Parliament
support.
does that all the time in the case of fiscal enactments. Will have amendments by the galore in the Income Tax Act. The moment a judgment comes, they will amend it with retrospective effect.
My lord, this, my lord, there are, we have, my lord, judgments on.
So what we call a validating statute or
My lord, we have judgments, my lord, whether this can be done or cannot be done, and to support the judgment of the division bench of the High Court, and we have filed an
but
affidavit.
then one thing, let's have conceptual clarity on what we are going to write on. I mean, what is the canvas on which we are going to write? If they are not arguing on the
They are not
validity-
ready to argue.
No,
We
ready to
want
argue.
them to argue.
They are not arguing. That's their choice. One second.
We shouldn't argue the 81 Act.
No, they said that let it go to the regular bench.
Just one
They
second.
say.
One second. We've got our notes. In the opening, they have said that they are not arguing on the validity of the 81 amendment, which forms the subject matter of the Allahabad judgment. So, for the purpose of this reference, then, do we proceed on the basis that the 81 amendment is a valid amendment?
It cannot be.
Oh, sorry, the 81, the other way around. Amendment is now effaced from the statute.
Yes, it's not, it does not exist on the.
By this court.
Yeah.
Whereas,
It's not stayed, it's not stayed. The court said status quo because they have granted reservation.
one second.
That was the state, therefore say that the
Where
status quo.
reservation, it is not state, otherwise it's status quo ante.
No, I'll show the
The
order.
order of the court. It's there. It is status quo ante.
No, you
Other than the issue.
You can't have it both.
If-
Let us be very clear.
If I remember correctly, what had transpired was, we were, that in case it's a minority institution, then the corrector will be issued in terms of the constitution and the rights protected under Article 30. So we are going on that basis.
All,
But to be fair to the solicitor, the argument of, which has been raised is that in Badshah, the court found three things. One, it was legally established. Two, in fact, de facto also, it was established not by the state. It was established by the state and not by the minority institution. And third, it is not administered by the minority. These are
And
three.
four, you have whatever rights you had, you have surrendered those rights.
So that is
That's a
part,
factual
that's part of the second, that it was not established and administered. It's a part of second and third itself because you surrendered.
So
those.
that factual
So-
finding that you have surrendered,
So your argument is even by adding even by deleting the word established from the statutory enactment, it will not unwind or rewrite the judgment of the
Aziz
Badshah's case, that it was de facto established by the state.
Mr. One more thing, Mr. Solicitor, I'll have a word with my learned colleagues over the lunch break. I'm just throwing this as an idea. It's not even my confirmed opinion. So it's just for the sake of a debate or dialogue in the court. You will also concede, and the other side will also concede, that the 81 amendment does have some bearing on the minority character of AMU. What bearing it has, it is for your argument, their argument, and we'll decide it. If we accept that the 81 amendment does have some bearing on the minority character of AMU, because let's face it, the object of the 81 amendment was to reaffirm the minority character. That's the whole purpose of 2L and that preambulary chain. Now, if the 81 amendment has some bearing on the status of AMU as a minority or otherwise, then can we really decide this without going into the validity of the 81 amendment? Otherwise,
that's precisely we requested.
because otherwise we'll be making.
No, that's precisely we
Because
requested.
our-
They were not comfortable.
because-
They said,
Mr.
go to the regular
Solicitor,
bench.
because look at it this way, Mr. Sibal, please look at it this way. We are a bench of 7. Can our judgment be made contingent on what a bench of a lesser constitution will decide on the validity of this amendment? If this, take it against you for a moment, just for the sake of argument. Suppose we reverse the judgment of the Allahabad High Court. And this is only for the purpose of testing the hypothesis.
Yes,
Not at all.
I-
Our mind is completely open on the 81, but I'm just putting it against you because suppose we reverse the Allahabad High Court and affirm the validity of the 81 amendment, right? In which case, the consequence of the amendment of 81 is to clearly confer it or recognize it, as they say, the minority status, whether it is declaratory or confirmatory.
Maybe subject to certain arguments
Yes,
which we may
that
make.
arguments are on both sides are open. In which case, how can we say that, well, we will decide this minority status of AMU dehosts the 81 amendment? And the moment you look at the 81 amendment, we have to necessarily look at the Allahabad judgment. So perhaps, I mean, we will all sit down at lunch.
But we
maybe for
have
5
been
minutes.
saying that right through.
At lunch, we will all have a confabulation between us because I have not had the benefit of my
Kindly
learning.
not recall, Lord,
colleagues'
it was
views.
our case that your lordship will have to go into the merits. They said, no, this question may be decided by
if
regular.
Mr. Solicitor, you can continue with the rest of your arguments. But if we come to the conclusion that we will have to decide the validity of the Allahabad judgment here, then you can deal with the validity of that judgment in your
No,
argument.
first let them argue. Lord, at that stage, Mr. Dhawan got up and said that I'll take 2 days.
You can support the judgment and we will hear them in response. That will be much faster. Otherwise, then we'll have to again go back.
Let them have, Lord, the.
My specific submission in the written submissions is that the 81 amendment is valid. Specifically there.
Obviously,
But
that's
once
the
the lordship said, let it be decided by the other bench, then I didn't complete the argument.
No, Lord.
I thought,
Getting away from it.
No, he said that it.
my recollection is that you said, I am not going into that, let it go into the.
Yes, and let it be done by the regular bench. That was Mr. Dhawan's submission.
If I remember correctly.
On our side, we were saying that you will have to decide it.
We are not hesitant.
All of us from this
We are
side.
not hesitant, but if I remember correctly, I had said, if you,
In
Maharaj,
on something.
हमारी सबमिशन कहाँ?
The consequence of the interim order is that AMU said we will not implement the 50% reservation. But the status quo, as on the date of the filing of the writ petition, was to be maintained. That is to say, when the petition was filed, Brother Dipankar Datta says 2004, the 81 amendment had already been brought into force. Therefore, the 81 amendment today, as a result of the interim order of our court, is operative.
that's right.
But the question is, Lord, without going into the validity of that judgment, it would not be possible for your lordships, my lord, in this.
Prima facie, you may be right on that. Mr. Sibal, just reflect on it at
No,
last.
we'll reflect, but what I said,
Stay of judgment.
1 second.
That's not stay of judgment.
Judgment, my lord.
Neeraj, look at the latter part. The latter part, that the status quo will be maintained as on the date of the filing of the writ petition.
That is
And
for
if you-
reservation.
That's for reservation, and also, my lords, the next line, since your lordship said should be considered the 81 issue, the next line says it's desirable
After the
that the
other.
larger bench
Then
considers
stay
the
of the
judgment
judgment.
also. Because your lordship.
There is no stay of the Allahabad judgment.
operation
per
of the
se.
judgment has not.
There is none. There
There's
is
no
no.
stay of the Allahabad judgment.
May I say something, bro? May I say? So may I give a little background?
Yes, it's status quo, Maharaj, for all other matters.
That is only reservation.
Put the question that should your lordship
Maharaj,
get into the 81 issue,
If your lordship,
81 amendment, the same order says that it is desirable that this matter should be considered by a larger bench, and your lordship that today seized of the matter. The same order. In the
Sir,
next
what
sentence,
has happened,
it's
my lord?
desirable.
What has happened, and I'm going to make this submission good.
Which is desirable, that matter be.
The matter is referred, not the question. That
remember-
was our case.
if I remember correctly, Maharaj, I had argued,
Don't argue and then.
if
now-
you set aside Basha. then
No, there is no setting aside. This is not an appeal.
If you do not agree with Basha, then 81 amendment doesn't arise. That's what I had said. If you do not agree with Basha, then the 81 amendment need not be gone into. It's so, if, what my Lord the Chief Justice said is right. If you say that Basha was right, Malaj, then the question of 81 amendment comes in. But if Basha was wrong, 81 amendment need not be discussed.
Vice versa.
Look, for
What I-
deciding whether it is right or
Allow
wrong,
me, sir, to continue.
81 will have to be examined.
I am not saying no, I'm just, please allow me. So if your lordships, Malaj, on our argument says that Basha is wrongly decided, you don't have to go to the 81 amendment. So decide that question, Malaj. What's the problem with that?
Point, Mr. What you're saying, look, Parliament amended the Act in 1981 to really, should we say in a colloquial sense, to override Basha,
That's right.
right? Now, what you are arguing is that if you come to the conclusion that Basha was wrong,
Yes.
then there was no question.
Yes.
But even so, if we come to the conclusion that that Basha was wrong, we'll have to still, we'll have to still deal with the validity of the 81 Act.
No, but then, Malaj, it goes without saying whether it is trying to override the judgment or not. It is established by the minority, recognized under the...
But suppose the lordship decides that Basha is right, then what?
Don't allow. That question will not arise.
What happens then if we decide that Basha is right?
If the Basha is right, Malaj, then the 81 issue will have to be gone into.
Only there.
Then by the regular bench, that's their,
Then only.
That is,
Problem is
that's
just
the only issue that is referred to your lordships, Malaj.
Just now you
Whether
said
Basha
that
is right or wrong.
1981 amendment survived.
Yes.
Problem is that just now you were saying that 1981 amendment is still operative.
If your lordship
Your
agree
argument
with
is that
Basha,
it is still operative, then we have to go into the validity of that.
Basha, Malaj. If your lordships agrees with Basha, then of course the 81 amendment is there. If you disagree, yeah. No, don't look at it today, Malaj. Just look at Basha, is it right or wrong? And if your lordship says the Basha is wrong, 81 doesn't matter.
what if the court says Basha is
That
right?
becomes an academic issue. Why? Because it is established by the minority and under 31 Malaj is recognized.
If we say that Basha is wrong,
Yeah.
then according to you, then the amendment in that sense recognizes what we feel also is the correct position.
Then, Malaj,
So what if we come to the conclusion that Basha is right?
then you have to go into the 81 Malaj.
But then if we say that Basha is right, then who goes into the 81 amendment?
Malaj, it is not referred to 7 judges. The 3 judges who would hear it will go into it.
That's the problem.
No, it's not a problem. That's the process.
That's not the.
That's the reference is only que Basha. The reference is not que the 81 amendment. I don't think that we should that we should go into that.
Keep having a bite. Conveniently, keep having a bite again.
On this at lunch, in deciding, your argument is that if you come to the conclusion that Basha is wrong, then the 81 amendment really becomes redundant. But just reflect on this. Can we decide on whether or not Basha is correct without looking at the statute as a composite whole, including the 81 amendment? Okay, technically today, true, as the solicitor said, 81 amendment is now not on the statute book because it has been set aside by the Allahabad High Court. but everything is live before our court.
No, Mullah,
Now, may not be live before the 7 judges, but it's live before the Supreme Court. Therefore, in deciding whether Basha is right or wrong, Basha itself has interpreted the provisions of the statute while coming to a conclusion, right? It relies on all the
Yes.
provisions of the statute.
that's correct.
Now, can we, while deciding on the correctness of Basha, say that we will look at only some of the provisions of the statute, but we look at the statute minus the 81 amendment?
Well,
That may be very artificial for us.
The loss is the
isn't it? I don't-
problem.
I
I'll tell you, loss is the
Just look
problem
at it
that will
that way.
arise. If I may, I'm sorry. Then your logic, just give me a few minutes, Malas. Either we look at Basha and on the basis of what happened in 1920. That is, look at Basha through the lens of 1920. Or we look at Basha in the context of Article 31 when it came into force in 1950 and what happened thereafter. His argument throughout has been, don't look at anything else, look at what happened in 1920. That's been his argument throughout. Please, if you don't want to look at Basha in the context of 20, please then look at this in the context when the Constitution came into force. Then apply all the principles of constitutional law in Article 30 to look at Basha. Then you'll have to do that also. And then 1981. That's not an easy exercise.
Lord Basha also, Lord examines
Therefore,
51
that question
and
will arise.
65th amendment.
Therefore, you'll have to look at Article 30, sub-Article 1.
And
You don't look at Basha
amendments.
on the lens of 1920 then. Then you'll have to do into all that. And my respectful submission is, Malas, that exercise need not be done. We are ready to, Malas, to argue Basha in 1920. Because that's how it happened. And that's throughout what has been said. Look at the Constitution, look at the regulations, look at what Basha says, look at what the rector said, look at what the chancellors have appointed. This is all Basha 1920. We'll answer that.
Basha, on the basis of the position as it stood in 1968.
Yes. Look at it and see whether it's it was established by a minority or not.
There is
It's all you have to look at.
There is one more aspect, my lords.
Let me just finish.
Supposing, my lord, your lordship considers 1981 Act also, and your lordship holds that that act is valid, it's unnecessary to examine
You
Basha.
are right, Mr. Devedi, but it's equally valid in case we hold that
I'm
Basha is.
saying consider together, not
So,
fight.
so the 81 Act, if it is valid, then Basha in any case is overridden then according to us, because, I mean, that's the argument on.
Even if Basha remains valid, the new act has come which is valid and therefore.
Lord, what they want to do, let me put it
Basha
in
relies
this
upon-
blunt,
there's
what
only
they
one-
want to do.
Basha relies upon 1951 and 1965
Amendment also, yes.
If part of the 1965 amendment has been done away with the 1981 amendment.
1981.
Yes, you go into that whether it was done validly or not.
Impossible to separate this.
Not looking at Basha in the context
That's
of
what we were
51
saying from
or
the beginning.
65.
Truncating.
You're not looking at Basha in the context of 51 or 65.
On one basis. This issue had come up earlier and we discussed and thereafter we proceeded on this basis. We are examining the validity of the ratio in Badsha.
That's all.
Number one. Number two, the reason was, why we said so was, we have to see the status of AMU as on the date when Constitution was enforced. In case we come to the conclusion, just 1 minute, please. In ways and Badsha, when we read, we found there were 2 aspects dealt with specifically in Badsha, or rather 3 aspects which were specifically dealt with in Badsha. One is, what is the effect of statutory enactment of a university, of creating a university? Badsha says, this is the enactment which establishes the university. This is the only aspect dealt with in 1981 amendment. The second aspect dealt with in Badsha, now we can hold, this bench can hold, yes, the statute established therefore AMU came into existence, in which case we uphold that, then 1981 amendment has to be examined. And that can be examined by a separate bench, because then the limited issue is, what is the consequence of that amendment. Number one, there the argument which will arise is, could the legislature, by merely deleting the word establishment, override the judgment of this court? That will be the issue, which is a separate issue. We have not addressed, nobody has addressed us. We have already gone through by about 5 days or 4 days. Nobody's addressed us on this. The second aspect, which is dealt with in Basha relates to administration. And it says it is not administered by the minority right from 1920 or as of in 1950. That's the most important legal issue, because both the sides concede that both the things have to be, in order to be a minority institution, it should be established as well as and administered. So that's a legal issue. The third point raised is, beholds the amendment made in 1981. The Basha holds it's not established, de facto established by the minority, and that issue is again before us. So really speaking, we need not go into 1981 amendment per se to decide whether Basha is rightly decided or wrongly decided.
Mr. Solicitor, Mr. Dwivedi, just 1 second. What we'll suggest is this. You are in the midst of your argument replying to them on merits.
Yes.
You can conclude your argument. Anyway, even if we decide to go into the validity of the Allahabad judgment, you said they should open first. We understand why you're saying that, no difficulty. So on this aspect, you complete your submissions. When we read Basha with you again, we will be able to then fine-tune our own understanding on whether that issue of the Allahabad judgment should or should not be decided together. We will read Basha with you. So when you are reading Basha with us, or for us, you can also focus on these issues which Mr. Dwivedi, Mr. Kaul and you are saying requires us to also decide the issue of Allahabad in this reference. So right now we can continue with your submission, because you're now on the almost at the latter fag end of your at the end of your submissions.
That's not the.
So we'll conclude your submission.
Really this.
It's the appropriateness.
Yeah, appropriateness. We will hear you at the end once you have argued on Basha.
Only give me a
We will
minute.
hear you for 5 minutes on that, and then we will hear the others anyway, because this has to be dealt with. The merits everybody will argue. Then on the appropriateness of considering the issue of Allahabad as well, we will hear each of you and then take a call.
I'll just add one thing. I bow down.
That's fine.
My lord, what has happened is this.
As far as the 51 amendment is concerned, Basha says it was just in conformity with the Constitution. We have argued that the 65 amendment was an emergency amendment, but it was reversed in 81. To that extent, my lord, we can certainly go into it depending on what your
It's not separable. On this argument, it's not separable.
Now you have shown us this. We have anything else that we need to see in the chart, so that then after lunch we can.
The chart, my lord, is.
Now,
But my lord, what is happening?
What is the remaining part that now?
What is happening is this. And let me, my lord, be a little more clearer rather than being diplomatic. What they want is, they are taking a chance whether Basha is right or not. If your lordships are satisfied that Basha is right, they will have a second round to say that even if 7 judges said Basha is right, now have a second round that now the basis is taken away and refer this question.
No, if Basha is right, no.
But that may not happen. In case we uphold Basha or agree with the ratio in Basha on the second and third aspect, they may not have any say in it.
My lord,
On the second and third aspect, that is de facto, it was established by.
No, I think what perhaps Solicitor is arguing is that if we come to the conclusion that Basha is right, then the issue of the validity of the 81 amendment will be before a lesser bench, a lesser
Yes,
constitution.
that's what we
three-judge
want, a
bench.
second round, my lord.
The argument there
And-
could be that, look, the basis of Basha is taken away by the
Therefore, no
1981.
need to go into this. That's all, Mother. That's all that there will be.
That's exactly what is the problem.
But there will be
That's exactly this.
There is no problem. You don't have to.
You
go into
can't
it.
have, my lord, this kind of
When
second bite at the
seven
cherry.
judges say Basha is wrong, what else?
We
is
can't
left
deal
in the
with
matter?
7-judge bench like this, my lord, that you decide what is comfortable to me and don't
I
decide
think you are
what.
more hurt about it than the 7 judges.
Both should be decided together. That's the appropriate.
Lord, yeah, the reference is the matters are referred.
On this, we'll just defer it a little bit. You conclude your arguments. We'll also read Basha with you. Once we reread Basha with you, you would have read Basha with two different
I
perspectives.
need to read, my lord, some debates in 65 and that would be very crucial.
All right, so now after this, you'll be referring to the debates
Yes.
and then directly take us to Basha, or what's the?
Yes, that's the.
And then we'll conclude.
There is only one thing I must.
So I guess about 20 minutes for the debates and about half an hour
I'll
for.
take seven sessions. I'll not repeat anything.
No
Not
difficulty.
repeat anything.
So, but now what remains from your argument is the debates and then followed by Basha.
Basha and few other points.
But there is only one thing I must point out, the legal obstacle for them is the court suggested by them. If Lord Basha is to be considered independent, not in the right of 51, virtually these proceedings will be sitting Lord like an appellate proceeding.
That is going to be my submission.
On principle, Lord, larger bench can go into the ratio, not the decision in that case. That's what.
Not the factual findings. That is going to be my submission.
To convert the reference Lord into an appeal.
It's not an appeal from 5-judge bench to 7-judge bench, intra-court appeal. The argument was, look at this, what he says, look at this, what he says.
That's going to be one of my functions.
We'll presently be open unless,
There are
until
some
we read
judgments
Basha.
I'll be citing.
Until we read Basha with the Solicitor General, let's, because, ultimately a judgment also depends on how it's, how it is interpreted by both the sides. So let's read Basha with you and then we'll take a final call.
And
Just
there are
one more
some
anomaly, my
judgments
lords,
followed on.
reflect on that, my lord. Just one more anomaly. Assume, my lords, my lords decide that Basha has rightly decided. By relegating the 81 question to a smaller bench, they will get the opportunity to argue that notwithstanding Basha, 81 amendment is declaratory and curative. Therefore, Basha will not apply. Please see the anomaly. Then 7 judges will now held Basha. And thereafter
have choice of two litigations, my lord, in a matter which are inseparable.
And again, anomalously, my lord, they'll argue what is something contrary to what is decided.
We'll not conclude an opinion at this stage. Let's, because Solicitor is on his legs now, and we have almost substantially completed the arguments. One more session is what he requires. So today we'll finish anyway, even by his own. Now, what next, Mr.
Yeah, yes.
Solicitor?
Lord,
One aspect also can be kept in mind, that is the referring order in the last paragraph refers the whole matter to your lordships. It says consequently we refer the whole matter.
We'll just look at that.
Your lordship.
Same time, whether the 1805 with the Union of India, against the Allahabad High Court.
yes, my learned friend is right, factual. And thereafter, Government of India, on a considered decision, filed an affidavit saying that we are not pressing this appeal. And we are supporting, when you say the full truth,
And
not half
so
truth.
technically on paper, it remains the appeal.
It remains, appeal
Subject, of course,
remains.
your appeal
I
that
have
you don't
not
want to
been
prosecute.
permitted to withdraw the appeal, but it is the stand of Union of India that judgment of the division bench is true.
And there's an appeal by AMU also.
Yes.
Separate appeal.
Several, there are several.
Solicitor General, in case we go into 81 amendment, then this issue will arise. Whether a legislative act or an amendment made by the parliament, subsequently you can withdraw. That will be an issue.
Correct, man, correct. And I'll have to address that, man.
Therefore-
I'm not running away
therefore-
from that question.
Correct. And there are two options before us. Either we accept the ratio in Basha. In case the ratio in Basha is accepted, then we come to three conclusions. It's de jure established by a statute and not by the minority committee. It is de facto established not by the minority committee. Three, it is not administered by the minority committee.
And four,
And-
surrendering.
Surrendering is part of 1, 2, and 3.
Yes, it's
1, 2, and 3.
a lot of people subsumed that.
It's subsumed in it, right?
Yes.
It's an argument dealing in support of that. Now, as far as 1981 amendment is concerned, it only deals with de jure, first part of it, de jure, establishment of the by statute. It doesn't deal with the other two. 81 amendment does not touch. And if I'm not mistaken, when we read Basha, it deals with all the three contentions.
Correct.
I think you're also of the opinion it deals with all the three situations.
Yes.
De jure, de facto, and administer.
Correct. Your lordship, sir. My lord, now,
If Aziz Bhasha is declared to be right by your lordships, then we would have to take recourse in 81. That's separate issue.
that's the whole point.
That is something, what is the effect of 81 amendment? That may have to be sent back to the High Court itself for fresh consideration.
No. It will be before a regular.
Decided here.
That will be a separate, let's not open up a new
That's
debate.
quite right, Lord. Quite right.
Lord, the position will be this, and I leave it at that. I leave it at that. My lord, the position will be like this. If they succeed, they get a second chance before a regular bench. If we succeed, then there is no chance. If they lose, I'm sorry, reverse. If they lose, they get a second chance. If we lose, we lose.
No, Mr. Mehta probably be a very limited chance.
Lord, your lordship knows the ingenuity, my lord. This is pending since years.
Because if we uphold on the second and third principles, even if they succeed on the first part, that statutory establishment has been taken away.
Lord, on that, we have sufficiently assisted your lordships, whether to take it up here or wait. It is entirely your lordship's
We'll
call.
just take it
I'll
on.
not.
We'll also like to read Basha with you and then I think. we
But
can
before
take up
that,
complaints.
Lord, what I have done is, Lord, I desired to read the entire debate of 65, amendment of 1965. But with a view, my lord, not to curtail, my lord, with a view to curtail my time, my lord, I will read only one, where the Honorable Education Minister, Justice Chagla, my lord, summarizes. Justice Chagla was, my lord, dealing with my lord, member of parliament called Frank Anthony, who had appeared in Kerala
He
education.
was a member of our bar.
Yes.
Yes,
Very
he was a,
Outstanding.
vibrant member of our bar.
yes, he was a, there are some
As a
interesting,
young lawyer, I've heard Mr. Anthony argue actually, Frank Anthony argue.
Lord,
The school is named after him, the Frank. Anthony
yes.
Bar.
Lord, he was
Yeah, he established.
a
it.
nominated member as an Anglo-Indian committee. He was a nominated member as an Anglo-Indian community. My lord, in fact, there is a very beautiful and interesting exchange between Justice Chagla and Frank Anthony, my lord, because both were, my lord, were from the same field. But the Justice Chagla had to say that you will have to concede that I know a little law, including the constitutional law. That's what Justice Chagla said in the debate, my lord. And Lord,
All right, let's see what are we seeing next now.
my lord, please come to, my lord, my note 2B. My lord, I am reading only one paragraph of Justice Chagla's my lord, address,
This is the parliamentary debate.
parliamentary debate in 65 amendment, when the 65th amendment was introduced. This is inter alia what he said. My lord, what he does is,
Mr. Solicitor, page.
I'm sorry, my lord, page 111 at the foot. But Justice Chagla narrates the history. Justice Chagla does two things. He narrates the history, which I have broadly pointed out to your lordships. And second, he says that there is a reason why our constitution makers have given them a separate status in the constitution itself as institution of national character. And thereafter, my lord, he says this. Lord, at the foot, 2nd September 1965. Your lordships would recall.
Can I request you, by chance, I opened up a wrong page.
2B.
In 2B. That's a speech of Monana Azad.
That's right.
Can you just read that also?
2B, my lord?
It's in 2B, triple one.
Right, 111 is the.
Can you
So
just read
page,
that?
your lordships open.
Triple one.
Triple one. I agree. Yes. Maulana Azad, my lords, that is 51 speech.
Yes, yes.
My lord, I wanted to read that, but I was curtailing myself. My lord, if your lordship, my lord, permits. As far as our constitution is concerned, honorable members are aware that Article 28(3) lays down that religious instruction cannot be made compulsory in any government institution. This necessitated a reconsideration of the question as far as these two universities are concerned. In both the universities, the Hindu university and the Muslim university, the religious instruction is compulsory. This was against the Article 28 of the Constitution and necessitated the making of certain changes. So the first change that is made is that religious instruction to be made optional. Instead of being compulsory, religious instruction will be given only to those students who themselves would ask for it. The honorable members are aware that a majority of students who get themselves admitted to these universities are such as want religious instructions being given to them. Another change has been made on the basis of recommendation of Universities Commission. The Commission recommended that in future, the President of Indian Union should be the visitor of all central universities. Having those powers with the Lord Rector and the Chancellor enjoy, it is against the spirit of our Constitution that the character of an educational institution be allowed to remain communal. All the institutions in the country should be Indian from all points of view and not Hindu, Muslim, Sikh or Christian. Naturally, the question that arose before the government was asked to what attitude they should adopt regarding the names of these two universities. The honorable members may be aware that about 2 years back in 1949, the government intended to introduce a bill consisting of only two clauses, one stating that the name of these two universities be changed from Banaras Hindu University and Aligarh Muslim University to Banaras University and Aligarh University, respectively, and the other making it clear that non-Hindus and non-Muslims can also become members of their courts. Nevertheless, the government prepared the draft bill and elicited the opinion of both the universities regarding that. The Muslim university was of the opinion that having been assured that general policy of the government was to change the communal character of the university, it would have no objection if the word Muslim was deleted out from its name and it being called Aligarh University instead of Muslim University. Then, my lord.
What, do we take it that Banaras Hindu University objected?
No. I'll find out, my lord, but possibly not objected. Possibly, my lord, but I can't make, my lord, a very accurate statement on that. Lord, Lord, as a matter of fact,
No objection. That is why it's.
why was it not changed? Lord, now, Lord, at the foot, Lord, this is Justice Chagla. Lord, after giving history, page 111, after giving the history of the formation or establishment of the university under the Act, and after saying that it has a separate constitutional status given by the Constituent Assembly, Justice Chagla says this, my lord, as a education minister. My submission to this house is that Aligarh Muslim University has neither been established nor is being administered by the Muslim community. But this is pre-Basha. Basha was not there at that time. It is not a minority institution in which Sri Anthony suggests. I will give him the reasons. You had first the Muslim college which was founded by Sir Syed Ahmad. Sir Syed Ahmad has asked the British government of those days to establish a university, and the British government established the university. Therefore, the establishment of the institution was by legislature and not by the community. Now, I cannot understand how it can be said that administration is in the hands of minorities. The administration of the university depends upon the law. During the British times, it depended upon this act. After independence, it depends upon the act as had been amended by the parliament. Does Mr. Anthony suggest that it is open to the Aligarh University or the Muslim community to change the administration of the university even to the slightest degree and go contrary to what the parliament has laid down? If the minority had the right to administer the Aligarh University, then it can have any administration it likes. It can change the administration and it can close down the university. It can change the constitution of the court or the executive council. Can it do so? Even the constitution of the court, of the executive council and the academic council is regulated and not by the minority community but by parliament. There is another aspect of the matter which Mr. Anthony has completely forgotten. He has attached great importance to the fact that under the Act of 1920, the British government, as a concession, said that the courts shall consist wholly of Muslims. Now, everybody knows that university is administered by the Executive Council and not by the court. The court, of course, is the supreme authority and it is like a showpiece. It meets once a year. Lots of people come there and make speeches and pass a resolution. But the day-to-day administration, selection, appointments, and so on are carried on by the Executive Council. And it is significant that even if in the British days, it was not provided that Executive Council shall consist only of Muslims. That clearly shows that British government did not concede the argument. Although there is no constitution then, the argument is now advanced by Mr. Anthony that the minority has a right to administer a particular institution. I say that this institution was not established by the minority, nor is it being administered by the minority community. That is the legal position as far as Article 30 is concerned. Now, my lord, may kindly, my lord, see 3A, Basha. Page 3, my lord.
Would you like to, before going to that, after that speech which we read of Mr. Chagla,
Yes.
read the speech of Mr. Somnath Chatterjee on the 81 amendment, which is the next
I wanted
page.
to, but I didn't want to.
That's the
I
next
thought,
page. That's the next
yes,
page.
yes, yes. Which was the
Is 113.
2B?
1-1.
I'm sorry. 2B. Yes, my lord. Leading member of parliament on the proposed amendment in 81 observed as under Somnath Chatterjee. Kindly see what this bill says. It seeks to restore the minority character of the university, and that is also in the statement of the Honorable Minister. So far as bringing into effect of this university is concerned, it was done under a statute. Everybody knows that. The statute has been construed by the Supreme Court in the background of Article 30 of the Constitution of India. It appears that the Supreme Court is thinking to have it considered by a larger bench, but the fact that the university was brought into existence by an act of parliament is a historical fact which cannot be ignored by anybody. This bill wants to restore the minority character of the university. Undoubtedly, we appreciate the great efforts made by some of the leading Muslims, intellectuals, and educationists in this country, and we greatly appreciate the efforts made by them. How can you, by legislation, change the history? We do not know. What I am apprehending is that by this, you are also opening floodgates of litigation, which we do not want. If an institution has been established in a particular manner by retrospective legislation, you cannot change its manner. The Supreme Court had held that it was set up by a statutory enactment and that it was not established by a particular community. The word establishment is now being brought in only with a view to attract Article 30 of the Constitution, because the language used there is established. Sri Somnath Chatterjee may be, but the minister herself has said that what is being done is that word establish is being deleted from the present act to show that it was not established by the statute. Can what was done in 1920 be undone in 1981 by a legislation like this? The fact cannot be altered by a legislation like this, which is supposed to have retrospective effect. What is the position? By omitting the word establish from the existing statute, they want to contend so. As I said, we appreciate the sentiments, but the question is, can it be achieved? It has been established by a particular community. Therefore, Article 30 can be attracted. That is the argument. The minister herself has apprehended it, and she has been advised, I take it, that it seeks the restoration of minority character. So my question is whether you can restore a character which was not there at the beginning, the character, pre-20 character, Somnath Chatterjee is talking about. Beginning, because we have to consider the statutory enactment which brought it into existence. Maybe this is done with a view to persuading the Supreme Court to come to a decision. We cannot visualize what the Supreme Court will do, but the statutory provision is being changed in order to pave way for the Supreme Court to come to a decision. There is also a change in the definition. The definition of the word university is now being changed. How can a fact be altered by a change in the definition? Please mark this. According to, I'm sorry, Your Lordship, sir.
Yes.
According to the proposed amendment, university means an educational institution of their choice established by the Muslims of India, which originated as Mohammedan Anglo-Oriental College, Aligarh, and which was subsequently incorporated as Aligarh Muslim University. Therefore, they now, by an amendment, want to make the university of a different origin from that was done when the law was enacted.
That's right.
Lord, another angle, Lord, which I'll come to later. Aligarh Muslim University, as Aligarh Muslim University, as it stood, is a part of the Constitution. Aligarh Muslim University, as Aligarh Muslim University, as it stood, is a part of Indian Constitution in 1963. Can you, by way of amending an act, amend the Constitution itself? The Constitution, when it used the word Aligarh Muslim University, understood it to be something else. Well, there is a separate argument on that. Well, I am not dwelling much on that. Now, my lord, kindly come to Aziz Basha, whose name, my lord, everyone has changed to their liking, my lord. 3A, my lord.
Come, Ashish.
Yesterday, even the religion was changed by the learned AG.
Learned AG made Aziz Ashish during the course of his...
On a lighter side, Mr. Dhawan referred to him as Aziz Basha. Then throughout, I have noted it. Mr. Sibal Aziz Pasha. And the learned AG changed the religion, my lord. It became Ashish.
But Aziz is common to all mostly.
Yes, now we go to Basha, which is volume 3A, page 3, right?
Yes, my lord. Please come to, my lord, page 7.
Yes.
So kindly, my lord, give me this indulgence, my lord. I'll read what is not relevant. I'll skip. Otherwise, I'll read, my lord, something even at the cost of repetition. These 5 writ petitions raise common questions and will be dealt with together. They attack the constitutionality of Aligarh Muslim University Amendment Act 1951 and the Aligarh Muslim University Amendment Act 1965. The principal attack is based on the provisions of Article 31, which lays down that all minorities, whether they are based on religion or language, shall have the right to establish and administer educational institutions of their choice. The case of all the petitioners is that Aligarh Muslim University, hereinafter referred to as Aligarh University, was established by Muslim minority, and therefore the Muslims had the right to administer it. And insofar as the Act of 51 and 65 take away or abridge any part of that right, they are ultra vires. Now, this was a question of fact asserted by them that it was established by a minority. Besides the principal attack, the 2 acts are also subsidiarily attacked for violating the fundamental rights guaranteed under Article 14, 19, 25, etc. Your lordships can, lord, skip. Then, my lord, the government opposes the petition. The petitions have been opposed on behalf of the Union of India, and its main contention is that Aligarh University was established in 1920 by Aligarh Muslim University Act number so and so, and that this establishment was not by the Muslim minority, but the government of India by virtue of a statute, namely the 1920 Act, and therefore the Muslim minority could not claim any fundamental right to administer the Aligarh University under Article 13. Thereafter, please see further. It was further contended that as the Aligarh University was established by the 1920 Act by the Government of India, Parliament had the right to amend the statute as it thought fit in the interest of education, and the amendments made by the Act of 51 and 65 were perfectly valid, as there was no question of their taking away the right of Muslim minority to administer Aligarh University, for the minority not having established the university could not claim the right to administer it. It was further contended that the fact that under the provisions of 1920 Act, the court of Aligarh University was to be composed entirely of Muslims did not give any right to Muslim community as such to administer the university, which had been administered by the authorities established by 1920 Act. This is a factual assertion made. My lord, I am respectfully, my lord, trying to urge that your lordships are virtually called upon to sit in appeal over a 5-judge bench judgment. There are adjudications on interpretation and facts. Lord, kindly, my lord, let me go further. It was further contended that the attack based on 6 articles that, my lord, your lordships can, my lord, skip. It is necessary to refer to the history previous to the establishment of the Aligarh University in 1920. My lord, now facts are being discussed. In order to understand the contentions raised on either side, it appears that as far back as 1870, Sir Syed Ahmad Khan thought that the backwardness of the Muslim community was due to their neglect of modern education. He therefore conceived the idea of imparting liberal education to Muslims in literature and science, while at the same time instruction was to be given in Muslim religion and traditions also. With this object in mind, he organized a committee to devise ways and means for educational regeneration of Muslims, and in May Mohammedan Anglo-Oriental College, Aligarh, hereinafter referred to as MAO College, was established thereafter and was, it is said, a flourishing institution by the time Sir Syed Ahmad Khan died in 1898. Now, today also, this is one of the top-ranking universities. Aligarh University is one of the top-ranking universities. It is said that thereafter the idea of establishing a Muslim university gathered strength from year to year at the turn of the century, and by 1911, some funds were collected and a Muslim University Association was established for the purpose of establishing a teaching university at Aligarh. Long negotiations took place between the association and the government of India, which I had shown to your lordships, about how, under what circumstances, with what conditions, in what covenants. That is what, my lord, factually is seen, which eventually resulted in the establishment of Aligarh University in 1920 by the 1920 Act. It may be mentioned that before that, a large sum of money was collected by the association for the university, as the government of India had made it a condition that a rupee 30 lakh must be collected for university before it could be established. They didn't do it voluntarily. That was a condition for incorporating or establishing and incorporating as an act of parliament. Further, it seems that existing MAO college was made the basis of university and was made over to the authorities established by 1920 Act for the administration of university, along with the properties and funds attached to the college, the major part of which had been contributed by Muslims, though some contributions were made by other communities as well. It is necessary now to refer in some detail to the provisions of 1920 Act to see how Aligarh University came to be established. The long title of the 1920 Act is in these words: an act to establish and incorporate a teaching and residential Muslim university at Aligarh. The preamble says that it is expedient to establish and incorporate a teaching and residential Muslim university at Aligarh, and to dissolve the societies registered as so-and-so and so-and-so, and to transfer and vest in the said university all properties, and mark, my lord, and rights of the said societies and of the Muslim University Foundation Committee. The rights are surrendered by operation of law. It will be seen from this that the two earlier societies, one of which was connected with MAO College and the other had been formed for collecting funds for establishment of the university at Aligarh, were dissolved, and all their properties and rights and all the and also of the Muslim University Foundation Committee, which presumably collected funds for the proposed university, were transferred and vested in the university established by 1920 Act. Section 3 of the Act laid down that the first Chancellor, Pro-Chancellor and Vice-Chancellor shall be persons appointed in this behalf by a notification of the Governor-General in Council in the Gazette of India, and the persons specified in the schedule shall be the first members of the court, and they happen to be all Muslims. Please mark this, Balot. The court says that they were not required to be, but they happen to be Muslims. Further, Section 3 constituted a body corporate by the name of Aligarh Muslim University, and this body corporate was to have perpetual succession and a common seal, and could sue and be sued by that name. Section 4 dissolved the MAO College and the Muslim University Association, and all property movable and immovable, and all rights, powers and privileges of the two said societies, and all property movable and immovable, and all rights, powers and privileges of Muslim Committee were transferred and vested in the Aligarh University, and were to be applied to the objects and purposes for which the Aligarh University was incorporated, not the objects of the original three institutes. All debts, liabilities and obligations of the said societies and committee were transferred to the university, which was made responsible for discharging and satisfying them. All references in any enactment to either of the societies or to the said committee were to be construed as reference to the university. It was further provided that any will, deed or other documents, whether made or executed before or after the commencement of 1920 Act, which contained any bequest, gift, etc., etc. Lord, kindly come down a little further, my lord. These provisions will show, Lord, fifth line from the bottom of that para, these provisions will show that three previous bodies legally came to an end, and everything that they possessed, but they were possessed of, was vested in the university as established by 1920 Act. Section 5 provides for the powers of the university, including the power to hold examinations and to grant and confers degrees and other academic distinctions. Section 6 is important. it laid down that degrees, diplomas and other academic distinctions granted or conferred to or on persons by university shall be recognized. Then there are section 7, then section 8, provided that university shall, now your lordships can skip this, there may not be. I'll read, right? I'll read it. Section 7 provides for reserve funds including the sums of rupees 30 lakhs. Section 8 provided that university shall
Actually, Mr. Solicitor, now thereafter, they are just reproducing the act.
I therefore
And
wanted
you
to
can
skip.
now go to page 841, Placitum C. Last sentence.
My lord, before that, my lord, page 11, 841, my lord, yes, class item C. My lord, PDF page 11. Your lordships, we are on the same page.
Page 11.
These provisions clearly bring out that the final control in the matter was with the Lord Rector, who was the Governor General of India. Then comes section 14,
Now, we
which
need
is
not read
again.
what section 14 says because we have read those steps. Now go to Placitum F. Their conclusions we will mark because before that they just reproduce the section and then Placitum F.
This provision, though not so all pervasive as the provision in section 13 of the 20 Act shows, that the visiting board had also certain overriding powers in case the university authorities acted against the Act, statutes and ordinances. There is no condition that Lord Rector and the members of the visiting board must belong to the Muslim community. Then, my lord, kindly come to, my lord, page 842, my lord, page 12 of PDF. My lord, select committee. My lord, this is important. It may be added here that the select committee, which went into the bill before the 1920 Act was passed, was not very happy about this proviso and observed, my lord, which proviso? Proviso to section 23 that all members of the court would be Muslims. They were not happy with that. And this is the finding of select committee. This is the observation of select committee. In reference to the constitution of the court, we have retained the provision that no person other than Muslim shall be a member thereof. We have done this as we understand that such a provision is in accordance with the preponderance of Muslim feeling, though some of us are by no means satisfied that such a provision is necessary. This was the genesis, my learned friend talks of genesis. This was the genesis, that what we are establishing is a secular university. But they said that we give in to their status, their request. Then, my lord, next is 23.2, your lordships can consider skipping. Section 24 dealt with executive council.
The last sentence in the paragraph, the power of making statutes.
I'll read them. I don't wish to. The way, my lord, petitioners read, I didn't want to read, my lord. They read, my lord. Anyway, my lord. Section 23.2, the court was to be supreme governing body of the university and would exercise all the powers of the university, not otherwise provided for by the 1920 Act, the statutes, the ordinances and the regulations. So, residuary power. It was given the power to review the acts of executive and academic councils, save where such council had acted in accordance with powers conferred on them under the Act, the statute or ordinances. So if they have acted in accordance under those, court had no powers. The statute to direct that necessary action be taken by the executive or the academic council, as the case might be, on any recommendation of the Lord Rector. The power of making statutes was also conferred on the court, along with other powers necessary for functioning of the university. Please pause here. The real section says the power of amendment is subject to the approval. He can even, Governor General in Council can even completely reject. Section 24 dealt with the Executive Council, 25 with the Academic Council and 26 with other authorities of the university. Section 27, 28. There is an important provision in section 28 which laid down that no new statute or amendment or repeal of an existing statute shall have any validity until it has been submitted through the visiting board, which may record its opinion thereon to the Governor General in Council and has been approved by the latter, who may sanction, disallow or remit it for further consideration. This provision clearly shows that the final power of the administration of the university rested with the Governor General in Council. Section 29 dealt with so-and-so, so-and-so. Please come to, my lord, slightly above H. no new ordinance amendment or repeal of any existing ordinance shall have any validity until it has been submitted through the court so and so, who may sanction allowed. This again shows that even ordinances could not be made by the university without the approval of Governor General in Council. If any dispute arose between executive and the academic council as to which had the power to make the ordinance, either council could represent the matter to the visiting board, and the visiting board had to refer the same to a tribunal consisting of 3 honorable members. My lord, I'll skip. Come to my lord C. Section 32 provided for admission of students to the university, and subsection 4 thereof provided that university shall not, save with the previous sanction of the Governor General in Council, recognize for the purpose of admission to a course of study for a degree as equivalent to its own degree, any degree conferred by any other university, or as equivalent to intermediate examination of an Indian university, any examination conducted by any other authority. This shows that in the matter of admission, the university could not admit students of other institutions unless the Governor General in Council approved the degree or any other examination of the institutions other than Indian universities established by law. Lord, please allow me to pause here. Lord, the university functions at 2 levels. One is, Lord, supervisory, decision-making, policy-making function, which was not in the hands of minority. And second, on ground, the principal, vice principal, they will be giving admissions, etc. That they follow what is decided. That's not the administration. That is, Lord, complying with the administrative guidelines or directions issued. Lord, section 33, Lord, I'll come to F. Section 40 is important and laid down that if any difficulty arises with respect to the establishment of the university or any authority of the university, or in connection with the first meeting of any authority of the university, the Governor General in Council may by order make any appointment or do anything which appears to him necessary or expedient for the proper establishment of the university or any authority thereof, or for the first meeting of any authority of the university. Unbridled powers. This again shows the power of the Governor General in Council in the matter of establishment of the university. This brings us to end of sections of 1920 Act. There is nothing anywhere in any section of the Act which vests the administration of the university in the Muslim community. The fact that in proviso to section 23(1), it is provided that the court of the university shall consist only of Muslims does not necessarily mean that the administration of the university was vested or was intended to be vested in Muslim minority. If anything, some of the important provisions to which we have already referred show that final power in almost every matter of importance was in Lord Rector, who was the Governor General, or in Governor General in Council, or Academic Council, I'll add, because I have shown the statutory provisions. Such were the provisions of 1920 Act. They continued in force in 1951 without any substantial amendment. In 51, the 1951 Act was passed. It made certain changes in 20 Act mainly on account of coming into force of the Constitution. We shall refer only to such changes as are material for our purposes. The first change, my lord, I can skip that, my lord. F, please come to classitum F. It was necessary to delete section 9 as otherwise the university might have lost the grant which was given to it by the Government of India. Further, section 8 of the 1920 Act was amended as the new section provided that the university shall be open to persons of either sex and of whatever race, creed, caste or class, and it shall not be lawful for the university to adopt or impose on any person any test whatsoever, etc., etc., my lord. Lord, kindly come to, my lord, last 3 lines. Ordinances to those we have consented to receive it. Clearly, section 9 was deleted and section 8 was amended in this manner to bring the law in conformity with the provisions of the Constitution and for the benefit of the university, so that it could continue to receive aid from the government. Some amendment was also made in section 13 in view of the changed constitutional setup and in place of Lord Rector, the university was to have a visitor. Section 14 was also amended and the power of visiting board was conferred on the visitor by addition to a new subsection 6. The next substantial change was that the provisos to section 23(1), which required that all members of the court would only be Muslims. My lord, I can, my lord, skip that.
Yes.
So please come to, my lord, classitum E. It is not our function in the present petition to consider the policy underlying the amendment made by the 1965 Act, nor
Because it remains the supreme
I'll
government.
read it fully, my lord. It will thus be seen by virtue of 1951 Act, non-Muslims could also be members of the court. My lord, correct, my lord. Yes, I am reading the full paragraph, sir. But the court still remained the supreme governing body of the university as provided by.
This is what is highlighted by them. Because once you hold that the court was the supreme governing body,
Yes, my lord.
then, and the pre-1951 position was that they were all Muslims. That's the contradiction pointed out in the judgment.
Yes, my lord.
Because here they clearly say the court will still be the supreme governing body of the institution. Just one. You said there's a distinction between policy and administration. I recorded it specific. What you highlighted was policy is the equivalent to administration. That will be slightly debatable. But here,
Would
the
your
contradiction-
lordships-
Just one.
I'm sorry.
Here, the contradiction which is pointed out is the judgment refers to several provisions, then it holds that court is not the supreme administrative body. And here in paragraph over here, they themselves contradict and say court is still maintained the supreme governing body of the court, of the institution.
Lord,
That's where the contradiction is.
Lord, would your lordships allow me to show section 23?
No, I'm just highlighting that.
No, my lord, at this juncture, it would be relevant, my lord. The statement which is made, but let us read the section as amended in 51, my lord. That's the answer, my lord. As amended, my lord. The court, and my lord, in 65, it even stopped being supreme governing body, but please see, the court shall, my lord, your lordships can have the chart, my lord, for time being, for my satisfaction, my lord. Supreme body with residuary powers. Lord, words don't confer powers. It is the real powers which have to flow from the statute.
Let's see 23.
Lord, 23 as amended by 51 Act. Because Aziz Basha is referring to 51 Act. Therefore, I am taking 51 Act. Because 65 even did away with, my lord, even that.
Let's read 23.
23-2.
Yes, let's see, read original 23.
Your lordship would like to read the original?
Yes.
Yes. My lord, your lordships can read this because original is retained. Whatever is.
Let's have 23. It's there in your chart, sir.
Second column.
Yes, let's read the first one and the second one.
Okay, we'll read the both. The court shall be the supreme governing body of the university and shall exercise all the powers of the university not otherwise provided for by
No,
this.
there are two things now. Just read part one also. The court shall consist of the chancellor, pro-vice chancellor, vice chancellor for the time being, and such other persons as may be specified in the statutes, provided that no person other than the Muslim will be a member thereof.
Correct.
Now, will it also mean, the proviso will also mean that the chancellor, pro-vice chancellor and vice chancellor should be Muslims?
It cannot mean. It cannot.
1 minute, please. No,
Only a minute.
no.
Only a minute.
Question to the other side, why? Will it mean that the
Lord, they can.
chancellor, pro-vice chancellor and the vice chancellor will be Muslim? Because if they are members of the court and the proviso say they have to be, all members of the court will be Muslim, can it be impliedly said that
No,
the
Lord,
chancellor, vice chancellor?
we had examined this, my lord. The real intent is that whoever they are, happen to be Muslim, happen to be non-Muslims, they would ex officio become members of the court.
Okay, we have understood. Now come to page,
Because,
paragraph
my
2.
lord, thereafter, whenever there is an amendment, this has not undergone change.
That's correct.
Yes.
But there is an amendment which, no, this portion that they shall be Muslim thereof has been deleted.
In
That is deleted.
1951.
That has been deleted in
1951.
Yes, yes.
So that's a big change. But
Yes.
now come to this part, paragraph 2.
Two, well, what was the
Just
power?
Just, I've got, just this,
I'll
the
read.
court shall
Well,
be
I-
the supreme
well, Lord,
govern, just one.
Yes.
The court shall be the supreme governing body of the university. That's part 1.
Correct.
And shall exercise powers of the university is not exercisable.
Not otherwise
provided. So there are two parts to it. One is it's a supreme governing body. That's part 1. The second is it shall exercise such other have the power to exercise such other powers which are not specified by the statute, ordinances, or regulations.
So, right, the miscellaneous, what do we call?
No, it's not.
Residuary powers.
That's part 2. Part 1 is it being the supreme governing body.
Thereafter, please read, Supreme Governing Body, and shall exercise all the powers of the university not otherwise provided for by this act, the statute, the ordinances, and the regulations. It shall have power to review the acts of executive and academic council, but which powers? Review of what? Save where such councils have acted in accordance with powers conferred on them under this act, the statute, and the ordinances. If something else happens, they can review the functioning or powers exercised by these three bodies. So here also they have residuary power. Then, and direct that necessary action be taken by the executive or the academic council as the case may be on any recommendations of the Lord Rector. Again, my lord, their recommendation is not binding. It goes via Lord Rector, and if the Lord Rector finds that yes, this is a power exercised by academic council or executive council, which is not their part of the power under the statute or ordinance, and the court has something to say, then my lord, their recommendation will go. So, my lord, it's a misnomer to say that it is a supreme governing body. Supreme governing body, yes, for anything other than what is provided for under the statute. Suppose the statute confers absolute power on executive council about admissions. Then, my lord, this body will, the court will not come into the picture. If the ordinance provides supreme power of, say, rustication of students or conferment of degrees or the quality of examination, that would be decided by those 15 or 16 people of executive council or academic council, not by 180 people, my lord, sitting together.
The court is supreme only in respect of those powers which are not expressly or by implication conferred on other authorities.
Yes, therefore residuary, that's my respectful submission.
That is what the provision says.
That's the, my lord, interpretation. Now, my lord, in 51, my lord, your lordship said, my lord, the second column, this proviso is deleted, provided that no person other than Muslim shall be a member thereof, and this power is also taken away. My lord, on the next page, and direct that necessary action be taken by executive or the academic council, as the case may be, on any recommendation of the Lord Rector. My lord, this is taken away. Otherwise, the residuary powers not vested elsewhere under the statutes or ordinance is remain.
What 12D may be read. The last line, D.
Last line of?
Yeah. The power is the-
Correct, my lord. I am on the act, my lord, right now. My lord, here when your lordships have this, my lord, can your lordships also see 65 amendment, because Basha considered that also.
Yes.
The argument on 65 amendment is, it's because of the peculiar situation which had come about in 65.
Yes.
It was a little disturbing situation.
Yes.
And
I
therefore,
think,
the amendment was a
There were
temporary.
several issues, my lord, which we may not go into.
I tried to find out what are the reasons.
Aligarh Jung was the vice chancellor, if my research is correct, very eminent diplomat, and he was so brutally attacked.
Became, governor of Maharashtra.
He was governor of Maharashtra also, my lord, and he was an ambassador in several important countries, and he was a very diplomat of repute. He was requested by Justice Chagla to go there and handle the situation, because there were several things happening which I am not right now going to, my lord, discuss. It's not in good taste. He was so brutally attacked that he had about 20 wounds on the vital parts of his body and he barely survived.
But their argument on that is that these were temporary in nature.
My lord, it continued.
Tide over the problem at that time.
My lord, kindly see thereafter 72. 72 is 65, my lord, please see. 65, my lord, they make it only advisory. But, my lord,
Their argument on that will be that if one holds that it is a minority institution in terms of Article 30, then these amendments may be wrong, may be contrary to the law.
then, my lord, what can be wrong?
Then those amendments are contrary to Article 30 because they withdraw. That's a separate argument. We understand
My
that.
lord, they have
That
not.
your argument that it is not a minority institution stands not
My lord,
support.
that has attained finality. My lord, that amendment on facts, your
Once
lordship
we
would
examine-
then be
once-
requested to sit in appeal. If your lordships have to, my lord, there are some finding of facts also recorded. If your lordships were to be requested to declare those amendments to be unconstitutional after, my lord, almost 60 years, I'm not on delay, and that too without putting any challenge, Lord, then it would be exercising the power of.
Basha, the challenge was there. Basha
Yes.
challenge was there.
Correct, my lord.
Basha, the
But
challenge.
kindly see the reference order. Reference order says there is a question frame. Reference order, my lord, unfortunately is not shown to your lordships. It's not that you entirely.
Reference order was shown to us.
That
There are two
reconsider
reference
Basha, entirely reconsider and take a different view. That's not, my lord, the reference. Reference is that there was a reference made to 11 judges bench in TMFI. What can be the indicia for deciding that this institution is a minority institution? That was not answered by TMFI. And therefore, the court refers it that Basha has something to do and impugn order in those appeals referred to Basha. Therefore, Basha is there. Not that the court is requested to take a different view sitting in appeal over Basha. I'm sorry, I'm better.
I have right to address.
Yes, my lord, just for want of better expression, what I'm saying. Well, let me, my lord, go further. It will thus be seen that by virtue, my lord, I have read that, my lord. It is remarkable that though the proviso to section 23(1) was deleted as far back as 1951, there was no challenge to 51 Act till after Ordinance 2 of 65 was passed. My lord, 51 is now, my lord, what, 74 years away. Back, my lord. The reason for this might be that there was practically no substantial change in the administrative setup of 1920 Act, and it was only when a drastic change was made by the Ordinance of 1965 followed by 65 Act that challenge was made not only to the 65 Act but also to this 51 Act, insofar as it did away with the proviso to section 23(1). It is not our function in the present petition to consider the policy underlying the amendments made in the 1965 Act, nor do we propose to go into the merits of the amendments made by 1965 Act. We are in the present petition concerned only with the constitutionality of the provisions of 1965 Act. If the provisions are constitutional, they were within the legislative competence. This brings us to the changes made in 65 Act, which have occasioned the present challenge. The main amendment in 65 Act was in section 23 with respect to the composition and powers of the court of the university. My lord, this I can skip, my lord, with your lordship's permission, unless other side wants me to reread because it narrates, my lord, what is 65 amendment. Please come to, my lord, 846 E, Classitum E. This was the contention. The contention of the petitioners is that by these drastic amendments in 1965, the Muslim minority was deprived of the right to administer Aligarh University, and that this deprivation was in violation of Article 30. Under Article 31, all minorities, whether based on religion or language, shall have the right to establish. My lord, that also, my lord, your lordships can, or my lord, I may.
The next line.
I'll read, my lord, whatever I
The
can.
next paragraph, portions of it have been quoted in the referral order.
Yes, ma'am.
And that is what is doubted by the bench of 3 judges. Whether establish and administer is to be read as establish or administer.
That's not their argument.
No, this is what the.
Yes, your lordships are right. But, my lord, we are going on a footing that they have also said that end is end. It is not disjunctive. But that's the only reference. But that I didn't hear them argue that should be either established or
I think
administered.
that's true. The arguments have proceeded on the basis that establish and administer means that both conditions have to be.
Must coexist. Yes.
The reference order specifically referring to all previous judgments insists on the fact that whether it's conjunctive or disjunctive. And that's why Yashpal and the NMEIC Act is also referred to, because the word established or incorporate were there. So one of our arguments is going to be the scope of reference was only on the issue of being conjunctive or disjunctive. The other issues of Bhasha, whether administered, established, or the facts of the case were never referred to. These internal contradictions are now being argued. They are not the subject matter of reference ever.
Lord, kindly
16F may be read, my lord, just after the first paragraph.
16F. my
We
lord.
shall proceed on the assumption.
Where is it? We shall proceed on the assumption in the present petitions that Muslims are a minority based on religion. Nobody disputes that, my lord. Nobody disputes that religion. What then is the scope of Article 30, Sub-Article 1, and what exactly is the right conferred therein on the religious minorities? It is to our mind quite clear that 31 postulates that the religious community will have the right to establish and administer educational institution of their choice, meaning thereby that where a religious minority establishes an educational institution, it will have the right to administer that. So kindly permit me to pause here. Lord, my respectful submission is going to be that if at all your lordships are called upon to reinterpret Article 30 in facts which are already decided, the choice will be choice to establish and administer, not the manner and method of establishment. That only Parliament can prescribe. That you decide, you make a university by an act of Parliament, you register as a society under the Registration Act, but that's a separate issue. Let me complete this. Lord, I don't wish to deviate. Establish and administer educational institutions of their choice, meaning thereby that where a religious minority establishes an educational institution, it will have the right to administer that. An argument has been raised to the effect that even though a religious minority may not have established the educational institution, it will have the right to administer it if by some process it had been administered by the same before the Constitution came into force. Now, my lord, having found a roadblock about establishment, they say, all right, but we were administering. Have a right to administer it if by some so and so. We are not prepared to accept this argument. The article, in our opinion, clearly shows that the minority will have the right to administer educational institutions of their choice, provided they have established them, but not otherwise. The article cannot be read to mean that even if the educational institution has been established by someone else, any religious minority would have the right to administer it because, for some reason or the other, it might have been administering it before the Constitution came into force. The words establish and administer in article must be read conjunctively, and so read, it gives the right to the minority to administer an educational institution provided it has been established by it. In this connection, our attention was drawn in Kerala Education Bill, where it is argued, this court had held that the majority can administer an educational institution even though it might not have established it. Kerala doesn't say this. I'm going to read 2 paragraphs from Kerala. It's a 7-judge bench. In that case, an argument was raised that under Article 30, Sub-Article 1, protection was given only to educational institutions established after the Constitution came into force. That argument was turned down by this court for the obvious reason that if the interpretation was given to Article 31, it would be robbed of much of its content. But that case, in our opinion, did not lay down that the words establish and administer in Article 30, Sub-Article 1 should be read disjunctively, so that though a minority might not have established an educational institution, it had the right to administer it. It is true that at page 1062, the court spoke of Article 30, Sub-Article 1, giving two rights to a minority, that is, one to establish and two to administer. But that was said only in the context of meeting the argument that educational institutions established by minorities before the Constitution came into force did not have the protection of Article 30, Sub-Article 1. We are of the opinion that nothing in that case justifies the contention raised on behalf of petitioners that minorities would have the right to administer an educational institution even though the institution may not have been established by them. The two words in Article 30 sub 1 must be read together, and so read, article gives the right to the minority to administer institutions established by it. If the educational institution has not been established by a minority, it cannot claim the right to administer it under Article 31. We have therefore to consider whether Aligarh University was established by the Muslim minority, and if it was so established, the minority would certainly have the right to administer it. Well, that was not argued that it is disjunctive. So we are also proceeding on that ground basis, my lord. Then, my lord, court quotes the Dargah Committee Ajmer case. My lord, this is where I say, when you surrender your right. I'll read, my lord, H. My lord, this is also 5-judge bench judgment in Dargah Committee Ajmer. If the right to administer the property is never vested in the denomination or had been validly surrendered by it, or had otherwise been effectively and irretrievably lost to it, Article 26 cannot be successfully invoked. Now, my lord Aziz Basha, the bench says, we shall have to examine closely what happened in 1920 when the 1920 Act was passed to decide, firstly, whether in the face of the Act it could be said that Aligarh University was established by the Muslim minority. Secondly, whether the right to administer it ever vested in the minority. And thirdly, please mark this, even if the right to administer some properties that came to the university vested in the minority before the establishment of Aligarh University, whether it had been surrendered when the Aligarh University came to be established. My lord, this is a question of fact the court poses for itself and answers as of fact that yes, you have surrendered. Before we do so, we should like to say that words educational institution are of very wide import and would include university also. This was not disputed on behalf of Union of India, and therefore it may be accepted. Thereafter, my lord, I'll come to D, classitum D. There is a good deal in common between educational institutions which are not universities and those which are universities. Both, I'm sorry, my lord, just before D, my lord, I'm sorry. The position with respect to establishment of universities before the Constitution came into force in 1950 was this: there was no law in India which prohibited any private individual or body from establishing a university, and it was therefore open to a private individual or body to establish university. My lord, therefore, my lord, I gave the history how the regime change took place. Till 56, anyone can establish university. MAO could have done it without, my lord, surrendering their rights before the Parliament. There is a good deal in common between educational institutions which are not universities and those which are universities. Both teach students and both have teachers for the purpose. But what distinguishes a university from any other educational institution is that a university grants degrees of its own while other educational institutions cannot. It is this granting of degrees by a university which distinguishes it from the ordinary run of educational institutions. See St. David College, etc. Thus, in law, in India, there was no prohibition against establishment of universities by private individuals or bodies, and if any university was so established, it must of necessity be granting degrees before it could be called a university. But though such a university might be granting degrees, it did not follow that the government of the country was bound to recognize those degrees. Britishers would not recognize those degrees. It was not recognized for government service. Therefore, at the cost of repetition, I say many universities came without an act of British Parliament, and they produced one of the finest alumni. I have the list, my lord, but that's not the relevant thing, my lord. I'm not going into it. As a matter of fact, as the law stood up to the time the Constitution came into force, the government was not bound to recognize degrees of universities established by private individuals or bodies, and generally speaking, the government only recognized degrees of universities established by it by law. No private individual or body could before 1950 insist that degrees of any university established by him or it must be recognized by the government. Such recognition depended upon the will of the government, generally expressed through the statute. The importance of the recognition of government in matters of this kind cannot be minimized. This position continued even after the Constitution came into force. It was only in 1956 that by subsection 1 of section 22, the University Grants Commission Act, it was laid down that the right of conferring or granting degrees shall be exercised only by a university established or incorporated by or under a central act. Lord, please mark this word, established or incorporated. Even if it is only incorporated, it is by the statute, my lord. So, my lord, I am on that amendment of 81. Deemed central act, a provincial act or a state act or an institution deemed to be university under section 3 or an institution specially empowered by an act of parliament to confer or grant degrees. Subsection 2 thereof further provided that save as provided in subsection 1, no person or authority shall confer or grant or hold himself or itself as entitled to confer or grant any degree. Section 23 further prohibited the use of the word university by an educational institution unless it is established by law. It was only thereafter that no private individual or body could grant a degree in India. The court now refers to earlier, that earlier there was no such prohibition. Therefore, it was possible for the Muslim minority to establish a university before the Constitution came into force, though the degrees conferred by such a university were not bound to be recognized by the government. This is the ratio, not that once the ratio as propounded before your lordship is that once it is established by an act, you cease to be a minority, and now the act requires, UGC Act requires an act, and therefore there can be no minority institution. No. Even after UGC Act, there are minority institutions. I have given examples how they are created. Here it was a sui generis case that you could have done what others did. Then there was nothing in 1920 to prevent the Muslim minority, if it so chose, to establish a university. But if it did so, the degrees of such university were not bound to be recognized by the government. It may be that in absence of recognition of degrees granted by a university, it may not have attracted many students. And that is why we find that before the Constitution came into force, most of the universities in India were established by legislation. The Aligarh University was also in the same way established by legislation, and it provided under section 6 of the 1920 Act that the degrees, diplomas and other academic distinctions granted or conferred to or on persons by the university shall be recognized by the government, as are the corresponding degrees, diplomas and other academic distinctions, etc. It is clear, therefore, that even though Muslim minority could have established at Aligarh in 1920 a university, it could not insist that degrees granted by such a university should be recognized by the government. Therefore, when the Aligarh University was established in 1920 and by section 6, its degrees were recognized by the government, an institution was brought into existence which could not be brought into existence by any private individual or body, for such individual or body could not insist upon recognition of degrees conferred by any university established by it. The enactment of section 6 in 1920 Act is a very important circumstance which shows that the Aligarh University, when it came to be established in 1920, was not established by Muslim minority, for the minority could not insist on the recognition by government of the degrees conferred by any university established by it. My lord, Vishwa Bharati University was a private university and was recognized after UGC Act came into force. Gujarat Vidyapith was a private university granting degrees, several legal and other luminaries as their alumni. They got the status of university after UGC Act. That is what Aziz Basha says. It is true, as it is clear from 1920 Act, that the nucleus of the Aligarh University was the MAO College, which was still then a teaching institution under the Allahabad University. The conversion of that college, if may use that expression, I'm sorry. Lord, the court is very conscious of using the word conversion. Because it died, the earlier body died, and a new body comes into effect. And therefore, my lord, the court says, if we may use this loosely, my lord, court uses, if the conversion of that college, if we may use the expression, into a university was, however, not by Muslim minority, it took place by virtue of 1920 Act, which was passed by the central legislature. There was no Aligarh University existing till 1920 Act was passed. It was brought into being by the 1920 Act and must therefore be held to have been established by the central legislature, which by passing the 1920 Act incorporated it. The fact that it was based on MAO College would make no difference to the question as to who established the Aligarh University. The answer to our mind as to who established the Aligarh University is clear, and that is that it was the central legislature by enacting the act that established the said university. As we have said already, the Muslim minority could not establish a university whose degrees were bound to be recognized by government as provided by Section Act. That one circumstance, along with the fact that without 1928, the university in the form that it had could not come into existence, shows clearly that the Aligarh University, when it came into existence in 1920, was established by central legislature. It may be that the 20 Act was passed as a result of efforts of Muslim minority, but that does not mean that Aligarh University, when it came into being under our 20 Act, was established by Lord, then your lordships can, unless the other side wants, my lord. My lord, kindly come to page 21, my lord, 851. My lord, F, my lord, the paragraph starting with F. I'm sorry, my lord, just below D. Just below D. We are of the opinion, my lord.
The court has proceeded on the foundation that MAO College and the Muslim University Association were institutions founded by the Muslim minority. They say that both the MAO College and the Muslim University Foundation, they were societies, they were founded by the Muslim minority.
Okay.
Second, they said that MAO College furnished the nucleus for Aligarh Muslim University. There are both these findings which we find. The first, which I said at the bottom of page 22,
I'm not disputing.
and the second at the bottom of page 19. But they say that because the establishment of the university was by an act of the legislature, therefore, it's not an institution which is established by the Muslim minority. And to support that, they say that there was no prohibition prior to 1956 on a private university, on a university being established other than through the route of lawmaking. Any person could establish a university. Therefore, they said that, look, you could have established a university yourself, but you chose the route of lawmaking by the imperial legislature. You reached out to the British government. And once the establishment takes place by an act of the legislature, The establishment is therefore not by is therefore not by
the
the
manner,
Muslim minority.
may I add with your lordship's permission?
That seems to be, that's the first part of the logic.
My lord, and
The second part of the logic they say is, look at the provisions of the statute, and the statute makes it clear that administration is not in the hands of the Muslim minority. A majority of the members of the court have to be Muslims, but there are, even insofar as the court is concerned, the electors to the court are not necessarily Muslims, one. Second, there are other institutions of the university in which the majority doesn't have to be. Not majority, you need not have Muslims at all. That's on the administration aspect. On the establishment aspect, this is the logic really.
correct, my lord, sir.
They accept that the nucleus is this. They accept that the institutions which provide the nucleus were Muslim minority institutions. But they say once you chose legislation, you cannot say the establishment was by the minority.
Yes, my lord, and may I add with your lordship's permission?
I think that really is the.
Lord, one more, my lord, one more. With your lordship's permission, I'll add, my lord. The honorable court, my lords, rely upon Dargah committee and examine the facts whether you surrendered your right to continue as a minority.
The scheme of the statute, the court has looked at in the first part of the judgment and the latter part of the judgment on the aspect of administration.
Lord, can I?
On the establishment, they follow the broad line of argument that, look, the establishment was by law.
Yes, my lord.
And the establishment being by law and having approached the legislature, the government then to pass this law, you didn't establish it yourself.
Lord, may I add with your lordship's permission? And how, my lord, I read the ratio, apart from what your lordships have said. Based on Dargah committee, the court also examines whether you had a right to continue as a university of your own. Answer the court gives is yes. Why did you not continue? Why did you surrender your right? Because you wanted your degrees to be
recognized.
And therefore, the court refers to Dargah committee 5-judge bench judgment that before constitution, if you have surrendered your right of administration, the matter ends. That is the second thing. And third thing, that everything which existed prior to the university coming into existence got dissolved by operation of law in the university with a mandate that whatever is now the corpus, including the debts, will be for the university, not for the objects of MAO.
Post-constitution, the fact that you seek recognition by the state is not an indicia of the surrendering of your minority status or the absence of minority status. Because post-constitution, now the law after, both before and after this judgment is that by seeking financial aid or seeking recognition, you don't surrender your minority status because
There is an act.
practically, if your degrees are not recognized, it's worthless.
No.
You're
There's
right,
one
there were
more thing.
other institutions pre-independence.
There's one more thing, my lord.
Post-independence, of course, after 1956, you cannot set up a university at all.
It's a crime.
It's a crime.
It's an offense to use the word university and to hold out that you are competent to allot degrees and diplomas is a criminal offense.
But that goes in their favor, not in yours.
No, my
I'll
lord.
tell you why. I'll tell you why. Because post-1956, you cannot award a degree unless you have been set up as a university.
Correct.
And that university has been established under law. Right? Therefore, it's a mandate of statute.
Correct.
Pre-constitution, at least there was an option. Post-constitution and post-1956 and the UGC Act, there is no option now. Therefore, the mere fact that you had to take the legal route in the sense, of a lawmaking route, the lawmaking route, would not by itself be a circumstance indicating the surrender of minority status,
No,
would it?
Lord, I'm sorry. The court says, and I, in my respectful submission, rightly, that others did not surrender established universities without lawmaking route and granted degrees. But you surrendered it. I'll come a little further. Because you wanted your degrees to be recognized by the crown. Lord, there were universities. Lord, I have given the list to your lordships, Lord, prior to the constitution coming into force. There were universities. Lord, how many? I'll just show the list.
The other day, but
that there were universities functioning, granting degrees, universities of eminence. And the 1920, there was no right to recognition, my lord, by the, even if, my lord, suppose I am my lord, sir so-and-so, I constitute a private university, forget minority, majority, and I have very good relationship with the Crown. Crown may accept my degrees, recognize my degrees. Crown may not exercise, my lord. There was no review, judicial review 226, nothing, my lord. There was no concept of fundamental rights for natives. So, my lord, the real ratio is that you had an option the way others had. You chose not to exercise the option. Post-constitution, such a situation will never arise. Because now you have to go before the, my lord, authority under the new act, not only UGC Act. Now there is a Minority Commission, Minority Educational Institutions Act. So now there is no difficulty. Now there would not be any situation which is akin to Aligarh Muslim University. Therefore, I started by saying that Aziz Basha is a fact-specific, act-specific, university-specific, sui generis judgment, deciding the certain factums, my lord, which it, my lord, which fell for consideration. And one of the question framed is, did you surrender your right? Because there was a right. There was no mandate that you go and get a lawmaking done. Others were exercising their right. They were granting degrees. Why did you not do that? You surrendered everything. Your property goes in the common pool. The property by operation of law is, my lord, vested in the new body which is created. That is the ratio. My lord, kindly, my lord, read further. My lord, kindly allow me, my lord, to read further. My lord, at page 21, my lord, the unnumbered paragraph. From the history we have set out above, it will be clear that those who were in charge of MAO College, the Muslim University Association and Muslim University Foundation Committee were keen to bring into existence a university at Aligarh. There was nothing in law then to prevent them from doing so, if they so desired without asking government to help them in the matter. But if they had brought into existence a university on their own, the degrees of the university were not bound to be recognized by the government. It seems to us that it must have been felt by the persons concerned that it would be no use bringing into existence a university if the degrees conferred by the said university were not to be recognized by the government. Gandhiji established many universities. At the same time, 1920, Gujarat Vidyapit, Bihar Vidyapit, Nalanda Vidyapit, Jamia, Vishwa Bharati, yes, my lord. That appears to be the reason why they approached the government for bringing into existence a university at Aligarh whose degrees would be recognized by government. And that is why we find section 6 of the act laying down that degree so-and-so. Now please see, it may be accepted for present purpose that MAO College and Muslim University Association and Muslim University Foundation Committee were institutions established by Muslim minority, and the two of them were administered by societies registered under the Societies Registration Act. But if MAO College was to be converted into a university of the kind whose degrees were bound to be recognized by the government, it would not be possible for those who were in charge of MAO College to do so. That is why three institutions to which we have already referred approached the government to bring into existence a university whose degrees would be recognized by government. The 20 Act was then passed by the central legislature and the university came into existence. Please come, my lord, at the foot H, my lord, classitum H. It appears, now my lord, factual adjudication is also done. It appears from paragraph 8 of the schedule that even though the members of the court had to be Muslims, please note, my lord, at that time, 35 were the members of the court, my lord, at the relevant point of time in 1920, had to be Muslims. The electorate were not exclusively Muslims. For example, 60 members of the court had to be elected by persons who had made or would make donations of 500 rupees and upwards to or for the purpose of the university. Some of these persons were and could be non-Muslims. 40 persons were to be elected by the registered graduates of the university, and some of the registered graduates were and could be non-Muslims. For the university was open to all persons of either sex and of whatever race, creed or class. Further, 15 members of the court were to be elected by the academic council, the membership of which was not confined only to Muslims. My lord, kindly pause here for a minute. My lord, this is being, my lord, decided at a time where only in recent past for them in 68, there were electoral colleges and constituencies reserved for Muslims where only Muslims can contest and only Muslims can vote. In 1920, 1930, etc. Well, possibly the judges were aware that this is a constituency where you have to be a Muslim candidate. Your electorate may not entirely necessarily be Muslims. Students can be of any community. Besides, there were other bodies like Executive Council.
On the administration aspect, right? This part of the discussion is in the administration.
Yes,
aspect.
Yes. Besides, there were other bodies like the Executive Council and the Academic Council which were concerned with the administration of Aligarh University, and there was no provision in the constitution of these bodies which confined their members only to Muslims. They can be, they may not be. Law did not provide for that. It will thus be seen that besides the fact that the members of the court had to be all Muslims, there was nothing in the act to suggest that the administration of Aligarh University was in Muslim minority as such. Besides, the above we have already referred to section 13, which show how Lord Rector, namely the Governor General, had overriding powers, etc. Then, my lord, again, my lord, the scheme is discussed, but please come to slightly above H. We are therefore of the opinion, my lord, fifth line from the bottom, my lord. We are therefore of the opinion that Aligarh University was neither established nor administered by the Muslim minority, and therefore there is no question of any amendment to 1920 Act being unconstitutional under Article 30, Sub-Article 1, for that article does not apply to at all to Aligarh University. Lord, then, my lord, kindly see. My lord, other arguments are rejected. I will not read, my lord. Other are 26, 14, 25, etc. My lord. They are under the lawmaking jurisdiction. You can never be a minority. That's the pitch at which the argument was placed. That now, if this is the law, there can be no university which is a minority university, because every university under UGC
Post 1956 now, as I said a short while ago, in view of section 22 of the UGC Act, you cannot establish a university except by law.
Correct, my lord.
Right? Therefore, the fact that you have established a university under the law, by a law, does not denude you of your minority status.
No,
Post 1956. And now you have the post 1956.
Post.
And now you have the MEI Act after 2006. Right?
Solicitor, just one. Before the 2004 Act, if we apply this ratio, that no university could be established as a minority institution until unless, because every time you required, after Yashpal, you required a statutory amendment.
Lord, I'll just answer that question. Lord, UGC Act provides that no university, whether minority or otherwise, can be without an act of legislation.
So therefore, act of
Deemed
legislation.
to be, Lord, would your lordship have UGC Act?
No, but therefore, whenever there's an act of, as per this ratio of this judgment, if there is an enactment by a law, whether by the parliament or by the state legislature, the act of establishment is by that legislation.
Either an act of legislation or under the UGC Act, you as an institution could go for conferment of deemed status as a university. So you could be a minority institution, you go to the UGC and you say, confer on me the status of a deemed university. So it could happen both ways. An act of parliament, as happened in this case, or as a deemed status of a university. Under section 22 and section 2F, section 2 subclause F, read with section 3 and section 22, a deemed status could be conferred on you. And therein, if someone did not do it, you could always challenge it, because it had to be a rejection and an approval.
But the deemed status, Mr. Kaul, the deemed status also would be conferred under the Act, right?
Yes.
Lord, may I possibly, I have understood the question.
The logic of this judgment is therefore that if you have been established by the Act,
Before the 56.
we'll come to the before the 56 stage.
Yes, that's the
The
logic.
logic of the, because there you had the option there.
Yes. And now, my lord,
Therefore, one thing, let's clear the cobwebs. The fact that you have been established by or under the Act does not in itself indicate that you have not been established by a minority,
yes,
right? You may be established by a
you will
minority,
have to be now.
right? Post 1956, even though you have been established by a minority,
You can still be a minority.
you still have to go through either the route of establishment by a law or under a law when you get the deemed university status.
Yes,
Therefore, the circumstance that the route which you followed was through lawmaking is now post 1956 irrelevant to your minority status,
mandatory now.
right? Because it is mandatory. Now, does that one difference which arose prior to 1956, namely, you had a choice of either going through the legislative route or seeking to establish your own university without any recognition, so that your degrees would not be
Recognition by the government.
recognition by the
That's
government.
the important fact.
But
Let's not forget.
In other words,
in those days, that was the spirit.
in other words,
And people used to, I'm sorry, my lord, I'm sorry. But people used to prefer graduates of such universities which were not recognized by the British. That was the spirit, my lord. Otherwise, my lord, would anybody have, my lord, Roorkee, IIT Roorkee was a non-law made university.
Look,
I have given the
Look,
list.
as far as employment is concerned, with hardly any private sector, it was all government employment. It was all
No,
government.
no, no,
employment.
no.
Most of it is government employment. Very, very.
Companies in Gujarat, I know of several shipping companies. Lord, Mohan Singh Oberoi's father was serving, Lord, as a graduate of one of the non-recognized university, as a manager of one of the leading shipping companies in Gujarat.
Now,
He was born in Gujarat.
Post constitution, you cannot say that, well, you sought recognition, and when you sought recognition, that now is at the cost of your minority character. That is plainly
Cannot be. I
post
concede.
constitution. That proposition of law is clearly unacceptable.
Very clear, but I
Right?
concede to that.
Now, therefore, does a proposition which ceases to apply or ceases to hold valid post constitution nonetheless become valid merely because it is the pre-constitution context?
Yes, but because there was
You
no
had a choice. But even if you had a choice, there's one very critical thing. That means that why did people seek recognition? People sought recognition for the reason that your students have employability, your students have credibility. Now, it may be that there were some institutions which had credible degrees even though they were not recognized by the government. But is that the price which we must necessarily ask minorities to pay? That's the point.
We cannot. As a government now, we cannot. Britishers could, they did, and they were paid.
Mr. Solicitor, one more question.
That's the point, really. I mean, I think that's the point that's the heart of it, actually.
The heart of it. The British government could, that you take it or leave it. These are my conditions.
There's much to be said on either side, which is why we are here. But I mean, that is really now that's the kernel of the controversy.
When we are looking at the constitution as framed in 1950, as enforced in 1950, at that time, the UGC Act was not there. If we accept this proposition, one of the issues which will come in, as you've argued, is that between 1950 to 1956, if any minority institution had gone to set up a university and seek recognition of the degree by the government, this ceased to be a minority institution.
Possibly. I'll answer that after considering. That's a potent question, a very relevant question, because that would be the same regime
So therefore,
which was available then.
When we use the term choice over here, choice includes university, there's no doubt about it.
Yes,
There's
yes.
no-
Not
So
the
when-
method of recognition.
Correct.
but-
So therefore, what was the intent behind Article 30? Was to provide certain safeguards and protect certain interests of the minorities. So if that be so, why should mere establishment by a statute be a disqualification?
Then, we are considering then.
And
Now,
therefore,
That's why I told you that post-independence, this argument can't hold water.
No. I'm
Now,
not.
do we therefore accept that argument merely because we are in a pre-constitution?
But that's the only thing, my lord. That's the only thing. That you were before the constitution, you had the option, you had your competitors, not competitor is not a correct word, but contemporaries who were,
So my only worry is this, that post-constitution, must we not really bring in all our rights realization
my lord,
in a manner consistent with the constitutional
not in a pre-constitutional era, there was no concept of minority,
Is that really,
no concept of
is that
fundamental
conceptually,
rights.
is that sound constitutional doctrine? Because ultimately anything that happened pre-constitution, does it not have to be brought into conformity with
My lord,
the post-constitutional rights regime? That is really,
my lord, there are judgments specific.
that is,
I won't do what he would otherwise would have done. My lord, there are judgments that in a pre-constitutional era, how you surrender your rights and what are the effect on post-constitutional regime. There are judgments. My lord. We are not, my lord, examining it in a
at the
barrel
same
kind of
time,
a-
we must read any plea in regard to the surrender of rights in a very strict context.
My lord,
Surrender of rights is not, even in the pre-constitutional era, surrender of rights to the law should not lightly assume. A surrender of rights, even in a pre-constitutional era, should be accepted only with on the strictest possible construction, because you're really in that sense stating that somebody who's otherwise entitled to a right has surrendered that right. Post-constitution, of course, there's no waiver at all. Our constitution doesn't accept
I'm not
waiver at all.
arguing that. Nobody can argue
We
that.
are now dealing with the post-constitutional assertion of rights of a minority, which founds its post-constitutional assertion on the basis of institutions which were founded pre-constitution.
My lord, that is where, my lord, we would
Now,
respectfully, my lord.
That is, I tell you, that's what's worrying. I
Lord,
mean, that's what is worrying.
another thing, my lord, I am also going to address your lord and assist your lordships on.
If you take a very formalistic view of this matter, found this whole constitutional argument on legal positivism, answer is very clear. Established by law, not established by the Muslim community, established by legislature. If you look at it in a very strictly legal positivist sense, there are clearly answers there.
Then your lordship.
But then that's the question. I mean, how do you mold the constitution?
only
you
one.
Look at it in a very legal, in a positivist way, or you look at it in a more
Lord, in
purposive
that
right
case, Lord,
concept way?
we
That's
would
the point,
not,
really.
this court as a constitutional court, Lord, saying something to those who stood by the freedom struggle and chose not to crawl before the Britishers. I'll address that. I'll address that. It's not a political argument. It's a valid argument of interpretation. I'm not in politics, my lord. Therefore, outside or inside, I never raise political arguments. But this would be, my lord, paying a negative tribute to all those institutions who chose, despite having an option, not to get into the lawmaking by the British Parliament. Lord, IIT Roorkee, my lord, I'm posing a question to myself, can we say that they didn't have jobs? Look, I can, my lord, again take your lordship. I didn't read all the list of all universities. All universities of eminence, many of which are now declared over the years after Constitution to be institutes of national importance under entry 63.
But IIT Roorkee and all these are very different institutions.
But this is an example. I will give other examples.
They were highly specialized institutions of excellence. AMU was not that. You must understand what is the purpose of AMU. It was to provide secular education to a community which was on the lowest scale of education in those times.
There were minority universities pre-constitution, still not, my lord, going before the British.
It was to provide a forum for upliftment of a community which had traditionally been deprived of education. That was,
that is, my lord,
of course,
can't be, my lord, with respect, my lord,
that is a whole,
may not be, my lord, a subject matter of a judicial decision making.
Lord, your lordship
That
allowed
can be a
30
good
second
jurisprudential
interventions.
issue.
Roorkee, my lord, was affiliated to Calcutta and then Allahabad. And in 1948, a provincial legislature, my lord, brought it into effect. That's
Yes.
from his own note, my lord.
Lord, my lord, this MAO was affiliated.
Can have other colleges because there is certain stipulations over here that within 25 kilometers, you can establish more institutions. You had schools which can come up within you. So university gives you a better status. College is obviously a secondary level, is much lower. Probably, what had happened, I'm not very familiar with the figures with regard to the level of education among different communities before partition. But probably what was happening was, there were communities which were inward looking. There were certain communities which were outward looking, and they were absorbing the Western education. They were more open to Western education. What the thought process which had gone on was, because there's sometimes you are more inward looking, you don't want to absorb new things. So let's create that opportunity for them. Let's create an opportunity for this community, and let's get out with all of us who have similar thought process, and let's have modern education. Then the issue obviously had arisen, as you pointed out, subject to what the other side say. Some people felt that we should not take any aid or recognition from the government. Some people felt that it is required.
Even
because
majority, I'm sorry.
ultimately, let's.
Hindu university, it was not minority. They
Look,
did
at
not
that
go
time,
before
nobody
the.
could visualize that India will be free or independence, we will have independent India. So one of the ways of serving the community is getting into the government. Obviously, it matters. Let's be put in.
Lord, I have not read
Reservations should
certain
matter.
things, my lord, but if need be, my lord, I'll show to your lordships what were the factors and considerations. But even Banaras Hindu University, it is nobody's case that Hindus were not, my lord, open to new ideas. Hindus were less educated. Hindus were, my lord, backward in terms of education. Even they had they fell into, my lord, that they went for lawmaking.
On the establishment aspect, Mr. Solicitor, I've raised some doubts which we have to answer. On the administration aspect, there are doubts which they will have to deal with, because administration, the Basha court has specifically gone into the provisions of the statute to indicate that administration was not in the hands of the Muslim.
That's a finding of fact, my lord. Whether there can be gone into merely because the composition is of larger.
And then the larger question, that if that finding had to be overcome, namely the finding that that administration was not in the hands of the Muslim minority, if that finding had to be overcome, then the 1981 Act had to completely redo the structure of the university. You can't merely by changing a definition undo. Then what you have to do is, for instance,
Composition of
composition of the court,
court, powers of the
composition of all
court,
these
everything will have to be redone. Executive council, academic council, court, pro vice chancellor, visitor, everything, my lord, their power, their composition, putting predominance Muslim minor, etc. My lord, will have to be.
So on the administration part, we now have an analysis of the statute by Basha, which says that administration was in that sense never vested with the, we will hear them on the, what they have to say to that.
I need to, my lord, say something, my lord, for some time, my lord. Can I do it next time?
How long now, Mr.
Not more than 1 hour, my lord. I genuinely, my lord, I have not repeated anything your lordships would, Lord, give that to me, my lord. I have not.
Can we cut it down to say about half an hour now, just the wrap up?
I'll not repeat anything, my lord. I don't wish to assure which I cannot, my lord. I'm
So
trying to be realistic.
We'll continue on Tuesday, brothers.
But I have a small request. Justice Khanna's computer prevents us from seeing his face. You're in Parda, my lord.
No, I'm not in Pata. I'm open to everybody. But you won't guess anything from my face, neither from my question.
No, my lord. We like to see it, my lord.
He's saying that he has a poker face when he's hearing that.
Obliged.